Well, on behalf of all the members of the bar and my own colleagues, we have pleasure in welcoming in our midst Justice Judith Prakash from Singapore, from the Supreme Court of Singapore. We are very happy that last few months ago we had the Chief Justice, Justice Sundaresh Menon, sitting with us. Now we have Justice Judith Prakash, who has come for the Delhi International Arbitration weekend. So she will be doing the keynote address this afternoon.
On behalf
welcome your leadership.
On behalf of the bar, my lord, may I extend our warmest welcome to Justice Prakash. Honor and a privilege to address her, even if it is on Indian constitutional law.
Yes, Mr. Saleh.
May it please. When your lordships rose for the day yesterday, I had just opened on the heading of construction of entry 50. And the three elements of entry 50.
Gulshan, oh, ma'am.
Copies have come. Thanks, Chris.
That constitution.
How many copies? Just see.
Of list 2.
My lord.
You can just read it out maybe.
Yes, in fact, my lord, I have taken the liberty
We can actually scan it and upload it on the system.
Well,
so
I
we'll all
have
have it.
taken the liberty of breaking it down into its elements. So it assists in an analysis.
We'll just have it scanned and uploaded. So everybody will have, you will all have it on the screen on that side and we'll have it on the screen as well.
I can also email it if that assists.
He'll just take a moment to upload it.
Please give him a copy also. Yeah, please take this. I'll be addressing your lordship initially on the basis of this piece of paper.
Yes, we got it. You got it, Mr. Dwivedi, on your screen. On the you'll have it on your screen also. You'll have it on that screen.
Fantastic.
Yes.
The first, my lord, is the entry as it reads. I have just broken it into parts. Taxes on mineral rights, subject to any limitations imposed by Parliament by law relating to mineral development. This is how the entry reads. There are three elements of this entry which your lordships will have to consider. And the analysis of which three entries elements of this entry were the bedrock of the decision in India Cements. The first is that these are taxes on mineral rights. Not on minerals. The second malady is that it is subject to, and I have taken the liberty of placing in bold the words, any limitations. Not limitations per se, any limitations. And the third element is that these are limitations imposed by Parliament by law relating to mineral development.
Yes.
There are alternative formulations by which our founding fathers could have written this entry. It should not be read, because that's not its language, as taxes on mineral rights subject to limitations imposed by law by Parliament, as the state would want to persuade your lordships to read it. But that's not the language. Because then one would say, where does Parliament say you shall not impose mineral tax?
Yes.
The last alternative formulation I'll come to a little later. Because, my lord, if the entry is construed, and this is not an argument in terrorem, if the entry is construed in its plenitude, that the MMDR as it stands today in no way constrains the state from taxing mineral rights, then tomorrow uranium produced can be taxed to death. So it will be mineral rights.
But Parliament still has a function. Parliament can certainly control that by imposing
It has done it.
limitation.
It has done it. Is my point. If,
Of course, that's your formulation.
Yes.
That Parliament has by providing
Correct.
for royalty in section.
now, why did I'm so
imposed
sorry.
it.
I'm so sorry.
But assuming that suppose the alternate formulation which was accepted in the subsequent judgment is held to be correct, that will never stop Parliament from.
The alternate formulation will.
For instance, Parliament can still make a bifurcation between the nature of the minerals which are of crucial importance to national security. Parliament can impose different sets of limitations.
But I'm sorry, that will again not then fit in entry 50, because it must be by law relating to mineral development, not a law relating to the taxing power of the state. The limitation must flow naturally from a law relating to mineral development.
But that goes against you, Mr. Salve, because if you see the alternate formulation which you say that Parliament has not made, the alternate formulation is taxes on mineral rights subject to limitations imposed by law by Parliament. If this was the formulation, then the domain of Parliament would have been much larger, because all that they had to do is to impose a limitation by law. The power of Parliament is much narrower because it has to be by law, and it is a law in the interest of mineral development.
I'm sorry, my lord, the point is slightly different. I see what my lord is saying. And in either way, Parliament can say a high tax on is counterintuitive to mineral development and limited. So either way, Parliament could have done it. The point is slightly different.
Mr. Salve, you gave example of uranium. Now, suppose government of India comes out with a law, Union legislature, putting constraints on imposing tax on uranium. That will be also a step towards mineral development.
I'm deeply obliged. I'm deeply
set.
obliged, my lord. In fact, my submission is going to be, that is why when entry 50 was crafted in 35 and continues, what they had in mind was, and that's clear from the language of the entry, I'm not going on any external material, that when Parliament makes a law relating to mineral development, the architecture of that law may itself impose limitations on what tax you can have on mineral rights. That is why what is the limitation flows from a description. The description is limitations imposed by a law relating to mineral development. So the test is, if by the kind of law which Parliament has made, a tax on mineral rights becomes incompatible with mineral development as contemplated by law relating to mineral development, that right gets limited. It's not as narrow as saying do,
right,
don't.
But then you have to demonstrate that a tax on mineral rights is incompatible with.
I'm deeply obliged.
If you
That's the
succeed in
exercise.
establishing that a tax on mineral rights is incompatible with the very premise of this law,
yes,
namely the MMDR Act, then
yes,
of course that is outside their domain.
That's my submission. That's what I have to develop. Your Lordship had one yesterday on more.
But that submission can't be an a priori submission based on the entries.
No,
it has to be specifically with reference to the provisions of the central statute. That's right. That this central statute clearly evinces an intent to exclude all taxes on mineral rights by.
I will not accept what my lord is saying, respectfully. Yes, we
also accept that a limitation we should not read in a very restrictive sense.
That's all that I was.
A limitation can also go to the extent of abrogation. Possibly. I mean, we are not, I'm just for the sake of a hypothesis. But because we have the same thing in the context of Article 19.2 to 19.6. Can a reasonable restriction go all the way to a prohibition? Our court has said in a given case, a reasonable restriction may go all the way to a prohibition. So assuming that a limitation can amount to a prohibition, that limitation must appear clearly from a law which Parliament has enacted, not just that this is contrary to the structure of the law or something like that.
No, I'm sorry, Madam.
Or the architecture of the law.
Yes. Why I am saying that what your lordships have to see, it's not obviously a priori. With respect, my lord, the Chief Justice is right. First of all, there must be a law relating to mineral development made by Parliament. If Parliament tomorrow, my lord, says, I don't need to do it, I leave it to the states in entry 23 to make the laws. And the end of the matter.
So this is a law relating to mineral development. That's what the law says it is actually.
Yes. Not just that, my lord. Parliament can only make a law relating to regulation and development. I'm not now on the semantics of development and regulation. I'm assuming development includes regulation. But how do you have orderly development unless you have regulation? Parliament under entry 54 and under entry 54 alone can make a law relating to mineral development. It may or it may not. If it doesn't, it leaves the field open to the states. So there is no a priori here. If Parliament takes that step, of, first of all, exercising its legislative power, 246 read with entry 54 of list 1, to make a law of mineral development. The words law of mineral development, therefore, is descriptive of the law, as its very language suggests. A law relating to mineral development. It's a label. And this squares entirely with the language of entry 54. Regulation and development of minerals, mines and minerals. That's the first important element in the interpretation of this entry.
The parliamentary enactment, Mr. Salve, is the MMRD Act. It levies royalty on mineral development. Are you saying that it is tax wearing the hat of royalty that is being levied by the central government?
But that's my third proposition.
You have that proposition?
Yes, I'll tell Manoj why. Let me tell Manoj what I'm going to develop, because.
But Mr. Sarve, that you already argued before us that royalty is not a tax. You said that royalty is not a tax. That's not your case.
That's why I'm saying answering this question there is a full dress answer to this. Where do I get? May I just state my points and then develop each one of them?
Yes.
Because I'm sure a lot of them, each of them will have a lot of
areas.
areas.
You may also keep this aspect in mind, that the limitation is on the taxing power of the state.
Of course.
So therefore, what is the limitation that this parliament can impose on the taxing power of the state? It is not any kind of limitation. Of course, it should be in the context of mineral development, but the limitation is on the taxing power, which is already there in entry 50 list 2. That context we cannot
Absolutely,
also leave aside.
Yes, sir. I'm going to be fully developing that.
And another very important thing is that entry 54 does not entrust Parliament with the entirety of the field relating to regulation and development of mines and mineral development. Entry 54 does not give to Parliament the entire universe of that subject, because it still qualifies it by saying to the extent to which, right? Which recognizes then in entry 23 of list 2 that the states also have power for regulation of mines and mineral development. Once Parliament makes that declaration, to the extent of that declaration, the state's power under entry under entry 23 is ousted. But therefore, when we are considering as to whether the taxing power of the states is excluded, as Sister Justice Nagaratna said, we must also bear in mind that the domain which is entrusted to Parliament is not an entire universe, but something which is carved out of that universe of regulation and development.
Recognize the taxing power on.
Malad, may I? Malad, first of all, as far as as my Lord the Chief Justice said, and I'm obliged for that expression, my Lord, I think that it's very helpful to have that expression in mind. There are no a priori limitations. Equally, the power of Parliament under 54, I'm not saying the law, the power of Parliament under 54 is untrammeled. To such extent means they can wipe 23 clean. So, my Lord, 54 has no limitations. He leaves it to the wisdom of Parliament to decide how much they want to occupy. And it is going to be my submission as has been held by constitutional benches, that the MMDR, it's both the avatar, the old and the new, occupy everything. So at the first constitutional level, there is no limitation on what Parliament can occupy. To the extent declared by law by Parliament means Parliament can take over pretty much everything. And your lordships have held that it has.
That would be with regard to entry 23 list 2.
Yes, of course, entry 53. No, my lord, the Chief Justice said it's not untrammeled. I'm saying the entry is untrammeled. Parliament may choose to slice off or may take the whole cake or a slice of the cake. And I showed yesterday the trilogy of cases. There are two more which I have to show because when I switch to interpreting entry 50, where lordships have said in a language which doesn't admit of any ambiguity that what has been actually taken over on an analysis of the act is pretty much the whole. Nothing remains really for the states to do. So that's one dimension. So my starting point is, Malad, there are three elements in 50 and each of them requires a rigorous analysis. If I may just digress for a minute and answer Mr. Justice Roy's question. The Lordship asked me. My third submission is going to be, even the expression taxes on mineral rights has to be construed, and it is going to be my endeavor to persuade the court that in the Indian constitutional context, it means the tax which is in exaction of a share like land revenue of the mineral rights, because we decoupled mineral rights from land. It's peculiar to Indian land law. Otherwise, mineral rights and land are married. Because of the peculiar way in which Indian land law developed, and there are 4 cases where your lordships have analyzed, we decoupled mineral rights from land. So land revenue would not include, because this also impinges on my entry 59 argument. I'm just foreshadowing, but answering my lord's question, my third point is going to be that therefore taxes on mineral rights here must mean an exaction by the state, like land revenue, of a share. Because it fell out of 49. Now you can't have taxes on land and 48, the land revenue, because minerals are no longer part of the land. So where mineral rights are created, you get an exaction. And if that's the correct contextual interpretation of tax on mineral rights, and the
You said an exaction by the state
of a share of mineral rights. If that's what really tax on mineral rights is, not Mr. Justice Vanchu's formulation of any tax on production, etc., then royalty is that exaction. So royalty is not a tax, but it is already the share fixed by the MMDR, and since that is taxed, that is why that context, as a sort of a paraphrase, it was said that royalty, in that sense, is akin to a tax on mineral rights. And then it became the catchphrase became royalty is a tax. So my lord, the Chief Justice is right. I'm not saying royalty generically is a tax. That may perhaps be, my limited legal skills don't allow me to go that far. Maybe somebody may be able to develop that point. I can't. I'm not conceding anybody else's case. My limited intelligence scholar doesn't permit me to develop that point.
tax, but it's an exaction by the state of a share of mineral rights.
Mineral rights. And if it is construed like that, and why was this not created in 35? It's something I have to address your lordship fully, because one can't just read the plain language. You have to see where it came from, how it came, and what are the legal framework in which it was introduced. And if you construe it that way, the whole thing just falls into place. Why was Section 25 put into the Act? Treating royalty and tax in the same breath as an exaction. Why a penalty and a prosecution for non-payment of royalty?
When you speak about how it came, we cannot also be forgetful of the Constitution Assembly debate when it was deliberately kept within the state's power, the power of taxation.
Yes.
Although a suggestion was made that it should be brought to the union powers list.
My lord, I'll tell your lordship why. I'm sorry, I'm digressing because there's a
No,
full
no.
dress argument. But
You may address it at the
No,
appropriate
but-
time,
but-
because you talked about time.
I must tell you why. Because one idea was move minerals to the union.
That's right.
They said, no, we will keep minerals. The same way industries, minerals will be kept to the states with the overriding power to come. In fact, one of the big criticisms has been industries. The declaration in the Industrial Development Regulation Act pretty much wiped the state clean. And that has been the problem.
But tell us this, Mr. Larve, I mean, this is just, it may be a conceptual issue. It's not necessarily against you, I just have this doubt. Suppose when the state taxes income,
Yes.
is that to be regarded as an exaction of the income? Or suppose a state, there's a tax, there's an excise on manufacture. It's not an exaction of the value of the article manufactured. Or suppose they tax corporate profits. Of course, the impact is that you are taking a share of the profits, but it's not an exaction of your
Excise
profit.
duty was in the old, if you go back to the historical definition of excise duty, the word excise was exactly.
It's a
Exaction.
tax, it's an imposition
Of
on
course, all exactions,
the
all
levy is
taxes
on
are
the
exaction.
subject. The levy is a tax, the levy is an imposed tax on a particular subject, whether it's income or the value of the article manufactured
Correct.
or services rendered,
But
now in the case of the goods and services tax.
For
But you
land,
can't say that the state is exacting.
I'm sorry, man.
If they tax us for our income, they don't take away our income.
No,
It's
no.
a tax on the income which you earn.
No, I'm sorry, I didn't mean it. Every tax is an exaction. Exaction by definition means something which is compelled by law, not something which is voluntary. So in that sense, it's an exaction by law. But my lord, the share, land revenue, for example, and when I deal with the Murthy aspect of the case, land revenue, for example, we said, what is land revenue? It reflects the sovereign share of the produce. That was land revenue. And when it comes by law, it becomes an exaction. So today a land revenue law is the shares, an exaction by the state of a share. Today, of course, the notion of a state has changed. It's not like a king or a sovereign. Today, it's a welfare state, etc., etc. But conceptually, they remain the same. But this is the third point which I'm going to develop now, about what is exactly a tax on mineral rights in the Indian context. So there are three independent elements. The first two go together purely as a matter of interpretation of entry 50 and the interplay. Yesterday, my lord, the Chief Justice asked me, why are you showing these cases? The interplay between 5423 and entry 50. Today, my lord, the state, and it will have some bearing when it comes in the context, but I'm just mentioning. Today, the state is the owner of minerals. But it cannot alienate its mineral rights. If the state wants to make a legal framework for alienation of its own mineral rights, it can't. Because if it had to make, it could either do it as an owner if there was no law on the field, then the law of contract would prevail. Or if the state wanted to make a legislative framework for alienating its ownership rights, it would have to reach to entry 23. Because as an owner, you can't make a law. You would have to find something in list 2. And that only place where they would find it is entry 23. And if 23 is swamped, the state is the owner but has no right to alienate its own mineral rights. So these are all, sorry, Manoj, I got a little ahead of myself. Let me come back, therefore, to the starting point of my submission so that I'm able to go down logically. There are three elements, therefore, I say, in this entry which require rigorous analysis. The first two go together.
Can you just again formulate them?
Yes. Not on a lighter vein, since nowadays we are all on YouTube when we are arguing here. And on social media, there is a brown colored liquid which my daughter has sent, which is for my throat. It's just that. Because I remember, Manoj, somebody had put up on one of these law websites, counsel drinking coffee. I wanted to clarify, Manoj. I shouldn't say he has come from London, he has done what English barristers do, carried something in a glass. Yeah. So, Manoj, I'm sorry. There are three elements of entry 50. I'm sorry.
Analysis?
Yes.
2 minutes में उठेंगे.
The first
Sarve,
is,
after you formulate it, then we will rise for just 2 minutes
Yes,
to
yes,
see
of
our colleague
course.
off, and then we'll come back in 2
of
minutes.
course.
But since we are in the thick of it, you can formulate
Yes.
so that you don't.
And that, Manoj, is actually set out on this piece of paper. That's it. The first is, it is taxes on mineral rights, and I've put it on bold because that's what your lordship will have to analyze. What is a tax on mineral rights? The second is, what is the kind of limitations which our founding fathers had in mind when they used the phrase of great width, any limitations? Not just limitations, any limitations. Why did they say any limitations? And the third is, they did not say by imposed by law by parliament. They made it descriptive. By law relating to mineral development.
Rise for 2 minutes. Yes.
metric.
Now, Mr. Solicitor has added to what your daughter has given you.
Yes, yes. The third element, and the second and third really go together. Any limitation relating to mineral development. I have to now establish, in order to succeed, that there is a law relating to mineral development, which there is. I don't think there's any cavil on that. And that such a law imposes those limitations.
The only one thing which we'll add to your second point, the law imposes those limitations
On the tax,
vis-a-vis on the tax on mineral rights.
I want to start with that. In fact, Marat, that's a point which, for want of a better expression, cuts both ways. I say it cuts my way for the following reason. We know that taxing laws generally operate in a field distinct from laws relating to regulation. We start with that premise. So that's an established constitutional premise. How will then a limitation look like on a taxing power if that limitation is to be found in a law relating to mineral development? What kind of limitation are we looking for? It is not a tax versus tax limitation. It's not Parliament saying we have shared, therefore I will tax it rather than you taxing it. I mean, that's what your lordships have held. Now Parliament can't tax it. No, that's a separate argument I'm going to address on what I call the Kannadasan conundrum. On whether they were right, I mean whether the judgment saying because 50 is denuded, it lands in 97, 97 is right or wrong. That's something your lordship will have to consider. But let's take it without any of those trappings. What should we be looking for? I start from there. Here you have a taxing law, but then you're told look at any limitations which may arise from a law relating to mineral development. Any limitation. So what are those kind of limitations which would arise? And that's where there is Malad offer the answer. Well, if the manner in which the law relating to mineral development is cast covers all aspects of mineral development, including the share of the state from the resources.
Just one second.
I'm so sorry.
So I took down is the manner in which the law relating to mineral development is cast includes all aspects of the matter, including the share of the state
In the mineral resource. that would then, and then a tax on mineral right. And why was all this brought? This was all brought, it was federalized, if I may coin that expression, rather than leave it at the state level, because of the uneven distribution of resources.
The way I formulated it is, if the manner in which the law relating to mineral development is cast includes all aspects of the matter, including the share of the state in the mineral resource, that would exclude the power of the state to seek any further exaction on mineral rights.
Yes, because ultimately, if we take a step back, you may call it tax on mineral rights, or what else is it? It is the state monetizing a resource. Land, tax on land, the state is not, and for public good. We all know today's states levy tax for public good, at least in theory. Not for enriching the coffers of a ruler, but for public good. So, and today, my lord, with 9B and 9C sitting there, including local development funding being raised under a law for mineral development.
But section 9 is only one kind of exaction.
Of course.
It is not all encompassing.
No, Malad, it's not. 9 is not the complete answer.
It is only one type, royalty.
Of course, Malad. No, I'm sorry. 9B, 9C.
9B.
In B9.
Yes. I'm only showing.
So what you are saying is that where Parliament wanted that the revenues of the states should be supplemented further.
Yes, it
in
has.
relation to mineral rights, then they have been given different types of heads for realization.
And Parliament has done it. Now, the import.
So 9 includes royalty. So really your argument is much more nuanced. You're not saying royalty excludes the fact that Parliament has imposed a royalty which can be realized by the state excludes the taxing power.
Correct.
But that where Parliament wanted to create additional heads of revenue for the
has.
states, it's doing so.
And Manoj, this has been.
Mr. Salve, 9B goes to a foundation, which is completely independent, and 9C goes to a trust. It doesn't directly.
In fact, a lot of the laws, when your lordship see, which have been struck down, were the 9B kind of laws, where they created, you may call it a foundation, a district mineral foundation, or you may call it a separate head, by which the state keeps it and uses it for demarcated funds. That's how these cesses work. I'll show my lot when I show the state legislation. 9B is pat what the states have been told you can't do now. I mean, subject to what we your lordship take on Kesoram versus India Cements. So, my submission is on a construction of entry 50. I'm sorry if I take a step back, therefore. I should be able to show that, first of all, Parliament has federalized this. Parliament does nothing under entry 54 and says, I leave it to the states, it is left to the states, untrammeled. A state may itself impose limitations on mineral development, but that's not good enough for 50. Suppose not 54 is not there, you can have under 23. Could I argue that under 23 this is done, therefore there is no limitation? No. Imposed by Parliament by law. So it limits it to a legislation referable to entry 54. All these little pointers in the entry are very important. Why? Because you have now, why was 54 at all there? 54 was put in there because it was a divide. Should we take minerals and put it in this union list? They said no. Even today, atomic minerals are still in this list. So the ownership must remain with the states. The ownership remains with the state. And for the bulk, the ownership is with the state. Only few, in 1 or 2 states where the land reform laws were not brought, the ownership remains. That Jacob's case analyzes it very well. So we now created a very strange legal architecture which is a complete departure from the general pattern of land law, we decoupled mineral rights from land. That's peculiar to us. Well, that's where Murthy got it completely wrong, which says land includes mineral rights. No use saying that. In India, it doesn't. And you can't use it as a measure. And that's a separate chapter I'll deal with. So, Malad, when 35 Act, and by the time 35 Act came, because I was checking, Malad, devolution rules didn't have something like tax on mineral rights. This came in 35. By 35, and Malad, Jacob analyzes this, when the British government started giving those zamindari rights, many times the British government excised out minerals. Why? Because Malad, war effort. They needed iron, copper, and most of all, they needed coal. Coal was the most precious at that time, in 30s, the most precious natural resource. So, in 35 itself, they gave it to the federal system that if you make this law, then your taxing power must comport to any law on mineral development, must not dilute or conflict with the law relating to mineral development. And when we have an all-encompassing law of mineral development, and I'll quickly now, your Lordship has seen all the sections, give the headings of all the sections. When you have an all-encompassing law of mineral development, to allow a handful of states who have the resources to upset fiscal burdens by taxing those mineral rights clearly drives coach and four through the law on mineral development. Because you must always remember the old adage, the power to tax is the power to destroy. If you have the power to tax, you can tax as much as you need. It's not a quantitative restriction, it's a qualitative restriction.
Yes.
So, my lord, it is my case, and I have to make that good, that entry 54 and the declaration and the provisions of the MMDR as we find them have been held to displace, although in theory it is to the extent, but the way we analyze MMDR Act, there's nothing left for the states on the ground. They may in theory have something available, but if we analyze the provisions of what actually the MMDR occupies, nothing remains. Why? Because in my respectful submission, the MMDR defines the minerals to which it applies. The only thing left out is if some mineral is not in the MMDR, then you leave it in 23.
State's property, therefore states tax it.
It defines the rights that can be created in those minerals. The state as the owner has no choice. It can only act under the union legislation. It can only grant prospecting licenses and leases in Form K and nothing else. So it defines exhaustively the rights that can be created. It defines exhaustively the terms and conditions on which those rights can be created and subjected to. The state or any owner for that. But let's focus on whether state is the owner. It cannot add one more condition or remove one condition. From the conditions added in the law and in the rules and in the forms, the state cannot say, but I want to protect myself and I add one more condition. It defines the fiscal exactions, and I'm deliberately using my not colorist language. I'm not using the word tax consciously. For the grant or creation of these mineral rights. What all can you recover? Surface rents, royalties, dead rents, spells it out in great detail. It lays down a lot, and this is critical. The levy, section 9 says you shall pay. There's no choice. If I remove mineral, I shall pay. It's almost like read like a charging section in a taxing law. So it creates a complete mechanism for the levy, the collection, the recovery, and the penal sanction. Nothing is left.
question in a better manner.
Yes.
What we have understood is that the only role state has to play is to enter into a lease deed. You execute a lease deed. You can't put any other conditions in that lease deed. Just assist us. According to you, this act is everything because it is for the development and regulation of the minerals which are being extracted and not so far as minerals by itself is concerned.
Yes. Not mines.
Tell us one thing. Keep section 9 in mind.
Yes.
It provides for collection of royalty. If state has only to execute the lease deed and do nothing, who will collect the royalty? And if somebody has to collect the royalty, that amount will go to whom?
Yes.
Can I just clarify on that, my lord, because that's the root question, possibly, my lord, troubling everyone, that state
Therefore,
would not get anything.
So therefore, understood like this, that the royalty is also to be collected by state government, but it has to be paid to the union?
No.
It goes to the state only. The only thing with that happens under this act is the fixation of
But
the
that-
amount.
Why are we going into all other issues? Your argument seems to be
Yes.
that by virtue of subclause 3 of section 9, it is only the central government by notification amend the second schedule.
Correct.
Therefore, the pricing will be in accordance with the second
That's the
schedule,
heart of the matter, my lord.
Correct.
so as to enhance or to reduce the rate at which it shall be payable. Therefore, the argument could be state cannot recover anything by way of royalty other than the price fixed in the second schedule.
Yes, and there is a reason why there is a structure, as the learned counsel has pointed out. Lord, as Lord, it is pointed out, and I will give facts and figures. Lord, every state has a different mineral resources. Some states are mineral rich, some are completely having no minerals. Lord, if it is left to the state government, there might be inequality or non-uniformity in the prices. The center also has to match the prices with the international pricing. And this exercise of of royalty fixation is undertaken, and I have reports I'll show,
That's very important.
in consultation with the state governments. Each state comes and say that we have this mineral, we have this problem, we need this revenue, so fix it like this.
But then,
And whatever is fixed
Mr.
goes,
Mehta,
I'm sorry.
Mr. Mehta, then it is whose case that the royalty which is being recovered by state is not in accordance with the second schedule?
No. I'm sorry. The point is different, my lord. May I continue my answer to my lord? I'm grateful to my friend for his intervention, because this is the heart of the matter. It's not just royalty, there are one or two others, but royalty is 9 points. What am I endeavoring to show? I'm endeavoring to show that these are limitations on a taxing power of the state. The state acts not qua state, not qua owner. The state is acting as a delegate under parliamentary legislation, collecting the royalty and keeping and then taking the royalty. But that is also under a law made by Parliament. Parliament has stitched up, as the law stands today, pretty much the entire area of the operation of mineral rights, including the fiscal burden, and I'm deliberately using my lord colorless language, the fiscal burdens to be placed. And as my lord was pleased to point out, 9.3, and the solicitor very helpfully intervened to say, there is a whole exercise done at the time of 9.3 to match competing interests, the interests of the state in resources, and by definition, interests of some of the states in resource. But not all the states have this resource.
And international pricing.
Mr. Sarvesh, now just to go back, you had told us that when we broke a link, The MMDR defines one, minerals to which it applies.
Insulting the
Two,
states on
the rights that can be created in those minerals. Three, the terms and conditions on which those rights can be created and subjected to. Four, the fiscal exactions for the grant or creation of the mineral rights. And five, the levy, collection, recovery, and penal sanctions.
Yes.
That concludes this part, or there's something more
No,
that you have?
I was therefore responding to what my lord asked.
Apart from this five?
No, these are the 5 points.
That's all, no?
Yes.
That's the.
Because if this is,
So we have not missed,
no,
anything. So that concludes this enumeration.
This-
That's why I just wanted to make sure that we have not missed something.
my lord, I will, if I had been in slightly better health, I would have given my lord a written piece of paper today.
That's all right.
I've had
And many of these things, we develop as we sort of.
Also,
have
my
the
lord,
dialogue.
I must say, the advantage of not having too much in writing is, as your lordships asked questions, a lot has changed in the last 2 days in the way I have formulated my thoughts. And these are last evening, today morning's thoughts. Because as your lordships ask questions, my lord, we also sharpen our focus. If I'm right, and I'll quickly give a list of the sections, because your lordships have read them in detail, so that the point is complete. But if I'm right on this, then I submit I have met the threshold of the entry. It's not a high threshold, I submit, of any limitations, not a specific targeted limitation on tax, of any limitations created by a law relating to mineral development. Because if it becomes incompatible, as my lord Justice Pardiwala was pleased to ask, 9 says you shall collect, this is the rate at which you shall collect. You don't get to fix the rate. And the union also will fix the rate in consultation with you, but once in 3 years. And not more than that.
Entry.
Now, why? Because you have federalized this. My lord, there are states which don't have mineral resources, but which may be close to a port. You want to manufacture heavy metals, you want to manufacture certain chemicals which are close to a port. You need minerals for that purpose. But you don't have those minerals. Now, if the state from where the minerals emanate upsets the fiscal apple cart by loading taxes, you are distorting the whole endeavor by Parliament to try and federalize the distribution, and I use distribution in the larger sense, of mineral resources amongst those who utilize it best.
But royalty is only one species of exaction. So only royalty and section 9A are considered under the act. There could be variety of exactions. That does not mean
With great respect, when we talk of taxes on mineral rights, it's a narrower focus. Your ladyship is right. And we do not, unlike entry 97, the state doesn't have the competence to conjure up taxes. Parliament can conjure up taxes. As Justice Chandrachud's senior judgment in one case borrowed an expression which Justice Venkatachalaya was very fond of, ragabag laws. You can have some kind of a tax put in some way. The Madura something judgment where there was an annuity added in the income tax law, and it was challenged saying this goes beyond entry 84. This court said, of course, it goes beyond 84, but so what? And they borrowed an English expression, ragabag laws. You can put anything in any law as long as there's a law and there's a charge and there's a levy and there's a collection. It's good enough. Doesn't matter what label you put on top of it. So the important point here is state can't conjure up different exactions.
that with regard to the scheme of exaction of royalty, there is a limitation by the central law on the state's power to exact royalty.
Absolutely.
Full stop.
But it can't exact anything more.
That is the point now.
Because all the terms and conditions on which the state grants mineral rights are exhaustively enumerated in the Act. It cannot add a condition, it cannot remove a condition. And I'm going to show that. If it was just Parliament saying royalty will be so much, you could have said, all right, this is royalty. How about paying me some ground rent also? How about paying me some share also? No. That's why the third, what the Chief Justice said, the 5 points which I made, it exhaustively sets out the terms and conditions on which these rights are going to be made. So it doesn't leave it to the state to say, I can add something more.
K doesn't stop at royalty. Form K, which is the lease deed, it says any other levies, fees, etc.
Whatever is there, please collect. No problem. You can add to that burden, is my point.
All right, Mr. Sarve, now I think we've really understood the heart of your
Yes.
submission. Now, what remains now? What would you like to?
Not remain. I tell my lord what all I have to cover. So
Yeah.
that your lordship will know. I'll stick to my estimate. I'll finish first. I have the points which I have to cover. I want to now, my lord, very quickly, because your lordship have seen the sections, make this point good by showing the provisions and correlating them to this point that it exhaustively sets out the terms and conditions. Then I want to show, my lord, 1 or 2 cases. So sorry. I want to show, my lord, 1 or 2 cases on how this has been understood. Then, my lord, I want to deal with, your lordship asked for judgments on entry 50. I start by saying none of them, I'm not trying to be facetious, none of them have put it in this way. But at the end, they all say the same. And I do want to then get into the Kannadasa, because one of the very important aspects of the matter, if 50 is denuded, does it go somewhere else? Yes. That also your lordship have to see, because your lordships in formation of 9, right, nothing should be left up. It has to look at all that have been said on the subject and decide this. Then, my lord, I have to deal, and I'm going to come immediately to the next point, on what is the meaning after this on tax on mineral rights. That's an independent argument. And it is going to be my submission that in the constitutional context,
Taxes to be levied.
you cannot construe it literally, because one has to see the constitutional context and the legal framework on which this was passed. In the constitutional context, a tax on mineral rights is a tax which gives the state a share of the mineral produced. And if that is so, and royalty answers the description of a share of what is produced, then in that sense, a freeze on royalty by Section 9 operates as a limitation on your tax on mineral rights. So in that sense, royalty is akin to a tax. I'm not arguing royalty is a tax per se. That's wrong. I mean, at least my limited intellect doesn't allow me to envision how one can show royalty is a tax. But in the constitutional context, that's how I understand the entry 50 judgments. And then I'll take your lordship through certain parts of India Cements and Kesoram and deal with it. So that will be complete. The second independent heading which I have to address, which has 2 dimensions, and I'll finish all that today. Entry 49 and 50. And that's a much simpler argument. Entry 49, I have 2 answers. When mineral rights are decoupled from land, you can't reach out to entry 49 to tax mineral rights. If I don't own something, you can't tax it.
You'll also have to deal with the point that, well, they're taxing land and using the minerals as a measure of the tax.
And there, my lord, fortunately for me, there is a very helpful recent judgment, which I would comment for your lordship's acceptance by a bench of 3 judges, where, my lord, for customs duty, first of all, what I call the RR engineering caveat, which came for the first time. This court said, This measure can't be taken to a point where it becomes a substantive tax by itself. And then the Acer case, where this court, in the context of imposition of customs duty, said something which is non-dutiable cannot be added as a measure of duty. So if something is expressly exempt from tax, you can't add it on. Now I'm saying something else. My submission is going to be twofold. First of all, my submission is going to be, as far as the measure argument goes, if you say you're taxing me on land, you can say your house, the capacity of your house to yield income. That's the principle on which we get the measure. Or the capacity of your land to yield crop. Or the capacity of your land to do all these. But can you say the capacity of my neighbor's land? I don't own my neighbor's land. If I don't own the mineral, how can you say that the capacity of your land to yield mineral will be a tax on your land when I don't own the mineral? That's one answer to the measure point. The second and more important point which I want to argue, which has not been squarely addressed, is in the context of 49, 48, 49, 50. Entries never overlap in law. There may be factual overlap, but when land revenue, taxes on land and taxes on mineral rights were separately treated, is it not clear that taxes on land cannot include tax on mineral rights? These are the two Murthy arguments. These are the two broad areas which I have to cover. I'm not going to take too much time on India Cement versus Kesoram, because if your lordships accept what I'm saying, it doesn't matter whether India Cement got it right or wrong, and if your lordships don't accept what I'm saying, it doesn't matter whether Kesoram got it right or wrong.
So what,
If I may
now look at Mr. Sarwar.
Yes. So my first point, to close, that yes, of course, sir. The MMDR Act, which are the sections? Your lordships have seen them. Which are the sections, therefore, if I may just enumerate very quickly. Section 4, page 924.
Volume?
I'm so sorry, volume 4, my lord. I'll very quickly just give the pages. Your lordships have seen these sections.
Yeah.
Section 4, the heading is enough. Prospecting and the mining operations under lease. No person can undertake reconnaissance, prospecting, mining, except in accordance with the terms and conditions of a permit, prospecting license as may be granted under this act. So mineral rights are created under this law on terms and conditions sanctioned by this law and under authority of Parliament. That's why, my lord, I took your lordship's time reading those three cases. Even where the state makes rules, it makes rules as a delegate of Parliament. So 4, my lord, runs coach and 4 through any suggestion that the state as the owner has any elbow room. No elbow room left. They can't have any more conditions. They can't add any more exactions. And 4th, 2, my lord, at page 925. No mineral concession. Now they've used one word, my lord, one phrase rather. No mineral concession shall be granted otherwise than in accordance with the provisions of this act and the rules made thereunder. So, my lord, now all mineral rights are granted under parliamentary legislation. It will have some bearing on whether you can then tax these rights.
To the next provision.
Section 5 at page 936. The choice of a grantee If your lordship sees 5, a state government shall not grant a mineral concession to any person unless A and B, provided that in respect of a mineral specified in Part A and Part B, no mineral concession shall be granted except with the previous approval of the central government. So it's not really the state which is granting, the state is acting under parliamentary law. And here, especially, we are really concerned with the big minerals, A and B, or schedule. It's with consent of central government that you even grant the mineral concession. And so much for being an owner. Section 6, I won't read it, Madam. Maximum area. See the degree of detail. Nothing remains.
Section 6, what page?
I'm sorry, Manoj, my learned friend wanted me to show, I'm sorry to go back. Section 5(2)(b), if your lordship turns back to page 936, the last line, no mining lease shall be granted by the state government.
5(2)(b).
Yes, Manoj. There has to be a mining plan, there has to be evidence to show existence of mineral contents, etc.
B.
B, Manoj, is at page 937.
Yes.
There is a mining plan duly approved by the central government.
What is the next?
6, the area.
Page?
Page 937. Don't bother about the details. Just showing the big headings.
Right.
7, page 938. The period.
Yes. What's the next one?
Then, Malad, section 9. It's been read to death, Malad. I'll read it again. Page 942.
Royalty.
And just for convenience, Malad, your lordship may want to note both 9.1 and 9.3 are at page 942. Your lordship has seen, I've repeated the point ad nauseum about the mandatory nature, blah, blah. The first schedule, just for convenience, Malad, they're at 982. I'm not going to read it. And the only thing, therefore, of apart from that, of real significance in the first schedule is, Malad, one understands why the federalization. The lordship just sees that for a minute at 982. Coal, lignite, atomic minerals. Malad, I'm sorry to digress. There's a case pending here, but I can give the facts. Different context. The state of Orissa, rich in coal, wanted to give a mining lease to a private company, a big private, which came and said, I will generate 500 megawatts of power. I'll give you half. I will set up an aluminum plant because you have bauxite. 10 million ton plant on which you will get GST plus excise, share of excise. And it will create 14,000 jobs between these two. The state of Tamil Nadu said, we need electricity. We need the coal. Now, if the power of taxation is there, you can tax coal. The state with its mineral rights. What happens? This is the balancing between the competing resources.
So
Tamil Nadu needs, it's an industrially developed state, needs power. It doesn't have coal.
Survey we've seen some section 9. We just
Yes.
quickly look at
So
you can enumerate.
the schedule, Malad, I wanted to say atomic minerals, etc. These
Right.
are the kind of critical minerals which are there. Then, Malad, the whole of chapter 3, page 946. This will have some bearing on the second heading on what is tax on mineral rights. Just please see the heading, Malad. And I had made this point yesterday. What flows from it, I will develop today. procedure for obtaining mineral concession in respect of land in which minerals vest in the government. So you recognize, my Lord Justice Pardiwala was pleased to ask me, where did the royalty go? Of course, it goes to the state. Their ownership is not touched. But chapter 3 says, I will tell you the procedure by which you will create mineral rights in yours.
All right. What is the next one?
Then, my Lord, your Lordship had already seen 10B. I'm just teeing off the section.
We're also taking it down so that at a glance, we have everything, you know,
Exactly.
in one page.
And more important, I thought of the soft pages. So page 948,
Page 948.
10BA, 950, (11A) composite licenses, 955,
Section 11,
11A,
page 955.
yes. Then we have, I'm sorry, 11B. Unfortunately, this thing is not. 11B is atomic minerals.
Page
11B, 11C, 956, 957. Then section 13, chapter 4, 958. Rules for regulating the grant of mineral concession. And the power of 13.1, and not much was made of this in the judgments I read yesterday, Your Lordship recalls, that the central government's power under 1, they said forget 2, look at 1, because 2 is always without prejudice to generality. Central government may by notification in the Gazette make rules for regulating the grant of mineral concession in respect of minerals and for purposes connected therewith. Maximum, the plenitude of the power. And Your Lordship remembers yesterday, those Constitution Bench judgments said, in the light of this, nothing remains for the state. I also gave the specific bits of this, which are relevant. I'm not going to repeat them today. And a similar power is given to the state, page 963. And I have to.
section.
Yes, sorry. Yes, you're right. Section 14 and 15, which are at page 963, minor minerals. And I have to show one judgment. In stone. Your Lordship said this also is under central law. Although it's minor minerals left to the state, but even minor minerals are controlled by central law. They leave it to the state to do it, but under the union legislation.
Yes.
Then, we have 15A, which is for the state government to collect funds. I had given Your Lordship 9BC, etc. The mirror image of that is.
Where do we get 15A?
15A is 965, right at the foot of the page. Now, there is one provision which I did not dwell on yesterday, so I'll just take 2 minutes on that. Chapter 5.
Where does it begin?
Page 967. Your Lordship knows, earlier there was this controversy about reservation. And the High Court held as the owner, you can always say, I will not grant. When it came here, Your Lordship said, apart from owner, really the limitation lies in entry 59 of the old concession rule. All that is now historical. Please see 967, section 17. And that's a little important. The provisions of this section shall apply in respect of land in which the minerals vest in the government of a state or any other person. But this cuts across both. Then subsection 2, notwithstanding anything contained in the Act, the central government, after consultation with the state, may undertake reconnaissance, prospecting, or mining operations in any area not already held under a mineral concession. And where it proposes to do, it will, in the official gazette, specify the boundaries, state the name of the permit, and specify the minerals. Now, subsection 3 is very important. Where an exercise of the powers under subsection 2, the central government undertakes reconnaissance, prospecting, or mining operations in any area, the central government shall be liable to pay reconnaissance permit, prospecting fee, royalties, surface rent, dead rent, and the case may be at the rate which would have been payable under the Act if such reconnaissance, prospecting, or mining operations had been undertaken by a private person in a mining concession. See the degree of detail they've gone to. That's all that you pay. You can't layer mineral rights tax. Tomorrow, central government may say, we will do this, and it will do it under an operating contract, say, by Coal India or by the National Mineral Development Corporation.
Right. Which is the next
Can
provision?
you tax that? You can't.
Which is the next provision?
And in this one, I'm sorry, one more thing. 17.3 on the same page.
Page?
I'm sorry, page 967 itself. I read 2, I'm just reading 3. Where the exercise of powers under subsection 2, central government undertakes, subsection 3. When an exercise of powers,
We've read it actually.
yes,
We've read it.
I'm sorry, 4. The central government, with a view to enabling it to exercise powers under subsection 2, may, after consultation by notification, declare no mineral concession shall be granted. Now see 17A on that very page, which is 967. That's important. And I want you to show something interesting. Yesterday, Melody asked me the development versus regulation versus conservation. Look at the heading of 17A at 967. Reservation of area for purposes of conservation. So they call it conservation. But if your lordship sees 1 and 2, central government, with a view to conserving any mineral and after consultation of the state, may reserve any area not already held under a license, etc. Where it proposes to do so, it shall by notification specify the boundaries and minerals in respect of which land will be reserved. 2 is extremely important. The state government may, and please mark, with the approval of the central government, reserve any area not already held under any prospecting license, exploration lease, or mining lease for undertaking prospecting or mining operations through a government company or a corporation owned, controlled by it, and where it proposes to do so, it shall by notification in the Gazette specify the boundaries of such areas, etc. So although you're the owner, nothing remains, the husk of the title remains really. You can't, a state can't even say my company will do it. It has to be with the approval of the central government. So first of all, it's under parliamentary law you do it, and then you do it with the approval of the central government.
Right.
Then, my lord, section 18, just I've read it fully, my lord, just to give your lordship the page 969, which is the duty of the central government, etc. And 18.2D, my lord, specifically talks of development of mineral resources in any area. I mean, of course, the power is very wide. All such steps as may be necessary. Then, my lord, 19 and 20, I won't read them, my lord. Sorry. My lord, my friend wants me to show 18A, that's the government of India can authorize GSI to make investigations. And then page 973, 19 again says, any mineral concession granted, renewed, acquired in contravention of the provision of the Act or rules or order shall be void and of no effect. So, my lord, 4 says these are the terms, and 19 says anything which doesn't comport down to the last detail is void. No elbow room left to the state.
That is all in the context of regulation.
This is mineral development, you call it regulation, you call it conservation. These are labels. You can put whatever label you want. That's how Parliament has said. But the important thing is when they enacted this law, one of the changes they made from Mines and Mineral Regulation and Development, they made it Mine and Mineral Development and Regulation Act. And then Section 20, 20 capital A, 973. 973, 20 capital A. Overriding power now to the central government to give directions. And I had shown my lord Section 21, the criminal prosecution.
Page?
I'm sorry, 973 is the power to give direction, my lord, the blanket power. 20A. Section 21, my lord, is the penal sanction for non-payment of royalty. 21.1, my lords, page 974. Then, my lord, as I said, my lord, the entire area of the penal sanction is governed by 22, 23, 23A, 23B, power to search, power to do this, etc. And even the preventing illegal mining and storage, the state makes rules as a delegate. Entry, inspection, so all the police powers are under this act. Then, my lord, 24A at page 978. I've shown that, yes. My lord, I have not troubled your lordship with the details, all the police powers, 22,
Right.
23, 24. And then 24A is only important because it defines what are the rights and liabilities of a mineral concession holder. And then 25 is the recovery of all sums. And that your lordship get at page 978. Your lordship have seen this section, your lordship also read the discussion of this section. Any rent, royalty, tax, fee or other sum. So they treat it, parliamentary understanding is these are all exactions. Rent, royalty, tax, whatever it may be. These are all statutory exactions and they are recovered as areas of land revenue under section 25.
The next provision?
So, the other provisions. And then your lordship saw the concession rules. They go down to the minutiae. Every little detail is in the concession rules. And Form K is page 1644. I don't not propose to read it. Your lordship saw it yesterday. Which has all the covenants of the lessor, covenants of the lessee. And I've already made the point. You can't add to or detract from this statutory basis on which these are to be granted. Now, if this is the law relating to mineral development, and if I am right that it's a complete package, including the fiscal burdens, then it is my submission that this satisfied the threshold of being any limitations imposed by a law limit relating to mineral development on a tax on mineral rights. This is how law eclipses a taxing power. My lord, I don't think And just for the completeness, now, just for completing the constitutional argument, please see some of the other entries, how taxing powers are shared. Because none of them require your lordships ever to look for any limitation arising out of a regulatory provision.
Yes.
So either we divide legislative powers. For example, we have in list 1 the spread of taxing powers. We have 82. And the corresponding on 46. So this is dividing legislative powers. Taxes on income other than agricultural income, taxes on agriculture. Very different.
Entry 82, list 1 and entry
With entry 46
of list 2.
of list 2. Entry 84 with entry 51 of list 2.
This is again division of
Division. Entry 86 of list 1. Taxes on capital value exclusive of agricultural land. Taxes on agricultural land.
entry 86 of list 1 with
Goes with, I'm sorry, with entry, it would go with entry 45, 46. No, not 46. It would go with 45, I suppose. Then the most specific one, very interesting, is 87, estate duty other than agricultural land. 48, estate duty on agricultural land.
yes.
So this is one form of subject division. We have now another form of sharing, and we find a new model in 246A,
The GST.
the GST. Where both union and state can impose GST and both can make laws. The area carved out is interstate. That's in subarticle. And there is only one malad which I found, the only one, possibly if I am subject to correction, the only one tax in entry list, in list 3, which is malad, which correlates to entry 57 of list 2. And that's a slightly different mantra.
Entry 57 of list 2 with
entry 35 of list 3.
yes, rates.
Yes. No, malad, they are taxes on vehicles. This is interesting, malad. Taxes on vehicles with a mechanically propelled, etc., used suitable for roads, subject to the provisions of entry 35 of list 3.
Entry 35 of list 3, I think, is rates. Right?
But entry 35 of list 3 is taxes. Mechanically propelled vehicles, including the principles on which such taxes are to be levied. Now, malad, this is a very interesting carve out. It's not a taxing power, it is a power to lay down the principles on which tax can be levied. In one sense, it is a limitation on the state's power to tax vehicles.
Yes.
The only other place, your Lordship recalls, where there was this kind of a divide was 286, the old 286. Parliament could lay down principles
Right.
to determine. That's one of 286 too. And it's still there. Parliament may formulate principles. So, they are all, this is possibly the only limitation on a taxing power, that the principles can be laid down in a concurrent list. That's why I argue, I make bold to argue, 50 is sua generis, where any limitation which flows from a law relating to mineral development eclipses a taxing power on the mineral rights. That's, I complete, my lord. That submission goes that far, unless there's anything more I can assist your lordship with on this aspect of the matter. There is a connected submission, equally important. What is the meaning of tax on mineral rights? But I've taken the liberty of first trying to finish all the submissions and then read the cases.
Much better, yes.
Because if I run out of time, I can always give your lordship a note with the
Absolutely.
passages.
Yes, Mr.
This,
That was really the conceptual aspect, which
That's
is the
more
heart of the
important.
matter.
which subject, where your lordships ask questions, we are also able to evolve. The expression tax on mineral rights must draw some sustenance or some color from its neighboring entries. And this is not some extraordinary proposition, my lord. Your lordships have applied this to taxes on betting, gambling, and luxury. Nocere socii. And there are three entries which we find in the state list. Entry 45, land revenue. Entry 49, taxes on lands and buildings. And these are untrammeled taxing powers. And then we have our entry 50. Two things must follow. land revenue, my lord, and if I have time, I'll cite the cases, otherwise I'll put them in there, is a well understood concept. Share of the state in the produce. Its genesis lies in what the British and then the zamindars used to collect from the tenants.
It is a share.
The lagan. That was land revenue. Started by the British, who started collecting land revenue. So if you produced that much of the produce, you had the superior title. And it sits side by side with an entry of tax on lands and buildings. And in the judgments, my lord, where the issue arose about wealth tax on land and buildings versus tax on land and buildings, or the income tax on rent versus tax on land and buildings, your lordships have always understood, the Privy Council understood in the 35 Act, and your lordships have understood this as land and building as a unit. For the Gujarat case, my lord, your lordship held, you can't say on a factory what goes on in the factory will tax. You have to tax land and building as a unit. These are inherent to the nature of the tax. Now look at mineral rights. The attorney, my lord, in his submissions, gave your lordships the UK duty on mineral rights. Makes perfect sense. Because where the minerals vest in the owner of the land, the creation of mineral rights is by contract.
Is?
By contract. It's like giving a house on rent, you give your minerals for exploitation. And the state can tax it. They call it duty on mineral rights. Because mineral rights can be created by the owner. So where the owner can create mineral rights, and monetize mineral rights, the state can tax mineral rights. We have removed, our founding fathers removed mineral rights from land. Because if we go by the logic that mineral rights are an integral part of land, then entry 49 was good enough. Or even entry 45 was good enough. Produce. If you're using it for agriculture, you give 1/3 of your crop. If you're using it to extract mineral, you give some part of your mineral, or if you're giving it to somebody to extract the mineral, you give some part of your royalty. And that would become land revenue. If it was a part of the land. But and there are some people who still own mineral rights. Jacob's case, I'm going to show. At the time, I'll show that. So it's not that this entry was written on, it's not that the entry was written on water. But the MMDR read that there are two kinds of ways in which mineral rights can be created. And it deals with it separately, albeit similarly. Mineral rights are created where the state is the owner of the mineral and where other than the state is the owner of the mineral. And this is right from the concession rules, pre-constitution. And therefore, my lord, reading 50 in the same sense as 45 and 49, a tax on mineral rights must be a tax on the monetization of mineral rights by the owner. Now, when the founding fathers, my lord, wrote entry 50, they didn't know ultimately what shape the law under 54, whether it will come, and if so, in what shape. But today, what we have in place is a legal regime in which mineral rights are created under a law made by Parliament, by a delegate of the Union, by a delegate created and recognized under a law made by Parliament. That's what your lordships have held in those three cases. That even when the state makes rules for minor minerals, and I'm going to show that Hind case where the granite was upheld, where Justice Chinnappa Reddy held, 23 is out. Entry 23 is out completely. So even when the state makes laws for minor minerals, it does so under the union legislation. So state is acting purely as a delegate of Parliament. And the mineral rights are being created. They are statutory in character. These are statutory grants because you have to make an order of grant. The lease follows the grant. I showed all the sections yesterday, but I don't want to repeat them. So you pass an order on grant. That order is subject to revision, etc., etc.
Was there 1935 Act was there?
Such a statutory grant of mineral rights by law made by Parliament cannot be taxed by the state, by the very by its inherent nature. And that also, my lord, in one sense, gels with the other point. Therefore, it's subject to any limitations. And today, the way the law is, you can't even create a right. Parliament virtually, my lord, decides who creates that right. Everything is done with the permission of the central government. Everything is done in accordance with forms. under parliamentary law, etc., etc. All that I've said all morning. So if entry 50 is read down contextually, to accord with similar entries. And why do I call them similar? And I'm going to show those cases. Mineral rights otherwise are inextricably associated with land. But there's an interesting passage of what generally mineral rights are.
Mr. Sarve, how can you postulate that merely because mineral rights are created by an act of parliament, that they are beyond the taxing power of the state?
No,
Where do we get that from?
Yes, I'll tell
Because
you.
you said that such
There
a
are three or
statutory
four
grant
steps.
under a law enacted by parliament cannot be taxed by parliament, cannot be taxed by the state. Yes.
Why I say that? There are 2 or 3 steps in my submissions. I say that as a matter of interpretation, 50 should be read in the same sense as 45 and 49. And should be limited, therefore, contextually. I'm not saying that as an absolute proposition of some constitutional immunity. I'm not putting it on that principle. If I'm wrong on my interpretation, of course you can tax, subject to the other part about limitations. I'm saying, my lord, contextually. And your lordships have, for example, the tax on luxuries. Your lordship said that contextually, we have to see where tax on luxuries. We used to all have taxes on cigarettes, and then a 5-judge bench struck down taxes on cigarettes, saying contextually and applying the principle of nociter associa, you have to see where it is found and in what context it sits and how it interplays with other interests. The lordship read it down to say it can only be a tax on an activity. I'm invoking that principle. I'm not saying a constitutional immunity.
NT 50 should be contextually limited.
Limited. Where mineral rights
Where?
are created by the owner. And there are areas where mineral rights may be created by the owner, even if they are restricted. If certain minerals are completely left out and they continue to vest in somebody, you may have. Today, Malad, the net is cast so wide by parliamentary legislation, may not always be so. For example, Malad, one step they already took.
But assuming that, mineral rights are created by a central law, the rights vest in the state, except where they are vested in a private person. Now, if the rights vest in the state, can the state not, while creating mineral rights or recognizing mineral rights which will be created in favor of a private party, say that we will tax those mineral rights?
Except here, Malad, I'm saying, please read that entry where the state as the owner can create mineral rights. If tomorrow we ever reach a legal regime where the state, qua owner, can create mineral rights, it may be able to tax them.
The distinction here is that the mineral right is created under law enacted by parliament, but it recognizes that the minerals vest in the state. Therefore, the state can demand royalty.
That's why I started by saying this is not a tax on minerals, it's a tax on mineral rights.
Right.
And I am submitting, if it is read in the same sense at entry 45 and 49, that this is a right to tax the owner alienating or monetizing a right. Because let's take a case where a private person gives a lease. You can tax the owner on the royalty.
So according to you, because the state is the owner, you can't tax yourself.
The state is the owner. State is just a owner. It's a husk of a title which remains of the state. You can do only what act and under parliamentary law to give it on those terms and get what you get. And you can't, you have virtually no incidence of ownership. Exercise of ownership rights remain with the state. Now, what I am saying is tax on land and building, tax on land revenue, or rather land revenue as a tax. These are all on a owner creating rights or exercising rights, enjoying the usufruct or allowing somebody to enjoy the usufruct. I gave my house on rent. I live in my own house. I cultivate a crop which I share, or I give it to a tenant who cultivates a crop and he shares.
A tax on land and building is agnostic to the use which the land or building is put by the owner.
Exactly. That's
Just the fact that you own the land or building,
that's what I'm saying.
right? So it's the fact that you own land or building as a unit
Is
makes
itself
you liable to pay the tax.
In other words, it is married to the ownership of land. And mineral rights are a facet of land. That one can't deny.
Did not get what you're saying.
But the tax,
Not under the Act.
under the act, the royalty is on the holder.
No, I'm sorry. That royalty, I finished that.
Yes. But mineral, the Government of India Act 1935 was there, and the 1948 Act was there. There is
Yes. No, in fact, I'm relying on that history.
I find it a little difficult to understand empty ownership or just the husk of an ownership. I think that's the expression you used. If somebody is the owner, I mean, what sort of a right you would have? That you will have only that right that the central government may wish to give, although you have a specific entry which permits you to tax. And you've also used an interesting expression, federalized, in the context of the uneven wealth, mineral wealth of the different states. But at the end of that federalized expression, you put Union of India at the end of it, and not the states when we think of a federal structure.
May I not answer both points? I'm deeply obliged. It helps me crystallize that. The federalized is on the first limb of my argument about any limitations. And I have finished that point, that there is a compact, complete code, and
That was your first submission, the first broad.
but I was going one step further. Nobody has adventured this. I'm trying to see if it makes any sense. If we consider 45, 49 akin to 50, why? Because these are three connected with land. I'm now not purely on what's the tax on mineral rights. Because the Indian structure was such right from 35 of the land laws, not the MMDR. The MMDR has never vested ownership in the state. It is firstly the British who started decoupling mineral rights from land by saying, I give you zamindari minus the mineral rights. And it's noted in those judgments. Or the Indian zamindars who had full right gave to their tenants rights other than mineral rights. Or sometimes they did. Then we had post-constitution, the spate of land reform laws, all of which took away mineral rights and vested in the state. So we have effectively decoupled one element of land, i.e. the mineral rights in the land. That's the first step. Recognizing this, don't disturb me like this. Recognizing this, the 35 Act put the power to lay a tax on mineral rights separately from a tax on land and buildings. In fact, according to me, that's where Murthy went wrong. What was it carving out? And if it is read in the same sense as 45 and 49, it then becomes a tax on the owner of mineral rights. How he monetizes them, you may monetize them by enjoying the minerals, or you may monetize them by allowing somebody else to excavate and recover. Whatever you call it, dead rent, royalty, share. But like 45 and 49, should be where ownership rights to mineral rights are available. And that doesn't fit with our present statutory landscape for the most. I'm not saying completely. It fits with some bits where we still have ownership rights in mineral. And if the state wants to tax them, it may stand on a different footing. That's as far as the point goes, but that's the point. But if we understand this on Nociter Associae, and I just want to show one thing, Manoj, as the starting point of the submission. What are mineral rights? Volume 4, 4F. This is the general law. I start from here. It's an interesting point.
Down to the center of the back at 2 o'clock. Sarve, we've now looked at, just to tell you how I've summarized it, I'm sure my colleagues have the same words. We have said reading entry 50 in the same sense as entries 45 and 49, the tax on mineral rights must be on the monetization of mineral rights by the owner.
Yes.
Then you said today mineral rights are created by a delegate set up under a law made by Parliament. The state acts as a delegate of Parliament. Such a statutory grant under a law enacted by Parliament cannot be taxed by the states. Entry 50 has to be limited or read down to accord with other entries, entry 45 and 49. Entry 50 should be contextually limited where mineral rights are created by the owner. The state is left only with a husk of ownership here. Entry 50 should, in other words, be limited like entries 45 and 49, where ownership of mineral rights is available to the owner.
Well, if this is on the transcript, I'll borrow it and put it in my submission. I don't think I could have put it better.
I saw that he's reading from shorthand.
May I now quickly finish this point, Bharat?
Sorry? It's a shorthand which you pick up with experience as a judge over the years, that's all. It's a long hand.
Shorthand difference.
For some of us, Bharat, who have beautiful handwriting, our long hand looks like shorthand. Bharat, may I now finish this point very quickly because I have 3 or 4 big points to cover. If your lordship just sees the classic statement on what is land revenue, etc., there is a very interesting judgment of a division bench of the Madras High Court. It's called Gopalan and State of Madras, nothing to do with D. Gopalan.
What's the citation?
This is Bharat 19. SCC में क्या है? Printed on top. Just one moment. We got it Bharat from the SCC. It's on the screen, but you want the citation.
71 LW.
Yeah, it's 71 Madras. I think it was Madras Law Weekly.
And what is the
What's the name of the case?
page number in
It
compilation?
is S. Gopalan and State of Madras.
In the compilation, what is the page?
Bharat, this is not in the compilation.
Not in the compilation.
Because when I was thinking of this, Bharat, after the interactions in court, I thought we were dictating.
What do they say? Let's see this.
The reason I am citing it is, Bharat, it's a good encyclopedia of the entire land law. So I get it all in one place.
What is the year of the judgment, by the way?
Bharat, this is 1957, I think.
The page, first page पे जाइएगा. Scroll नहीं कर सकते क्या हम लोग?
Scroll नहीं
क्या है यार, citation नहीं है अपने पास.
होगा.
अरे कॉपी भी है, कॉपी तो ये है.
फिर इससे भी पता चलता है ना.
It is AR 58 Madras 539 or 1958 to Madras Law Journal 117.
AR 58 Madras.
539.
That would be good enough.
But they looked for it in the SCC and this is how it came up. DIRs are not. I was told All India Reporter was going to put everything online, but I don't think they put their High Court. Your Lordship sees page 673.
Is there online agreement?
Twenty-four.
Yeah.
Sovereign is entitled to levy tax on all lands. Such a right is one of the prerogatives.
You can have it. But please ignore the marking. The discussion is at page 673. I'm not going to read the whole thing, but land revenue was challenged. On the left-hand side, lower column, it starts with third line. Its well-known system of permanent settlement or Lord Cornwallis was introduced only in a few places in the old Madras presidency, and the board of directors of East India prohibited its extension to the rest of the presidency. Thereafter, collection of revenue by way of village settlement or by grant of lease of the village to a middleman, to a renter, a headsman, etc., etc. But not the whole. I'm not going to read
Actually,
the
the question was whether this is collection of assessment and collection of land revenue is
there's a-
violative of Article 265.
very interesting.
So the court says, no, this was a power which was inherent in the sovereign even before the constitution.
It's a
It
very
was
interesting
continued by Article 372
That's
and therefore it's protected.
But why the reason I went to this judgment is it's one of the best discussions of the history, and it gives it all in one place rather than
Yeah.
going all over the place. Page 674, from the very early time, land revenue was recognized the item of revenue for the same Mr. Soundaraj Iyengar in land tenures. After referring to the ancient Hindu scriptures and smritis, said that the lawgivers have laid down most distinctly that the sovereign is entitled to a share of produce on the land for protecting their life. If your lordship has that.
Yes.
And then he discusses the whole matter. I won't read the whole thing.
Yes.
It will be of assistance to your lordship because it puts it all in one place. So land revenue, tax on land, all this have their historical origins in a share. And that is why, Manoj, till 35, even under the devolution, there was no such thing like tax on mineral rights.
Yes, Mr.
This is for that first point. If Lordship, at any point, will not need me to develop further, but I'm going at a little trot because I want to finish today. And also, Malot, an interesting passage in Mupil Nair, the famous A.T. Mupil Nair, known for its Article 14 propositions. It is volume 5, page 175. I just want to read one sentence. At this is Malot, I'm sorry, this is 61.3 SCR 77. At page 183, para 8. About 3, 6, 7 lines from above. The Act in terms claims to be a general revenue settlement of the state. Ordinarily, a tax on land or land revenue is assessed on the actual or potential productivity of the land sought to be taxed. That's the point which I was making.
Where is that, Tara?
But I'm so sorry. It's para 8 at page 183.
And which line?
About 6 lines from the top. The Act in terms
Yes, yes.
claims to be a general revenue settlement of the state. Ordinarily, a tax on land or land settlement revenue is assessed on the actual or potential productivity of the land sought to be taxed. In other words, the tax is reference to income actually made or which could have been made with due diligence and therefore is levied with due regard to the incidence of taxation. This is not the general notion. of tax on land, of land revenue. But I made a broad statement, one not have to make it good. That's how it is understood. The rest then one of their lordships discuss about if you have a flat rate, then how it violates Article 14. Now changing tracks a little, Maran. Now where do mineral rights sit? In all these?
Because the entry uses the expression in the plural, mineral rights. It doesn't
Rights.
say mineral right. So it's really a conglomeration of all the rights to minerals which
Correct.
in here in a person.
Yes, that's very important. And otherwise, but for the kind of legal system which sort of evolved in India, mineral rights were an integral part of land. Your Lordship sees the passage from McGarry. It's in volume 4F.
Page?
PDF 2. I'll just read 4 or 5 lines. This is the standard textbook, the law of real property. There is an ancient maxim, Cusius as solum, ejus as usque ad coelum edat inferos, meaning the owner of the soil is presumed to own everything up to the sky and down to the center of the earth. It has been criticized, but the presumption that remains firmly a part of English law, encapsulating in simple language the proposition of law, which has commanded general acceptance. Above the surface, the development of powered flight will make it impossible to apply the presumption literally. The owner's rights and airspace above the land extend only to such height as is necessary for ordinary use and enjoyment of the land. As regards the rights beneath the surface, the maxim applies. And the owner is presumed to own the minerals beneath. For practical purposes, the rights downwards are unlimited. There must obviously be some stopping point as one reaches the point at which the physical features such as pressure and temperature render the concept of strata belonging to anybody so absurd that it's not worth arguing about. As to the land itself, the owner and fee simple is prima facie in possession of, and therefore entitled to any chattel, which is not the property of any known person, which is found under or attached to the land, in a field or in the bed of a canal. All right, I have to stop here for a minute. Now, there's one story which Mr. Parasaran used to tell with great delight. He said the landlord let a big piece of land out in Satyug. The tenant, while plowing the land, discovered a pot of gold. He went to the owner and said, this doesn't belong, this doesn't go with the land, this is yours. And the landlord said, I have given you the land and all it yields, so it is yours. They went to the king. By the time they went to the king, Kali Yuga had come, so they changed their pleadings. The tenant argued, actually, you're right, it's mine. The landlord said, no, sorry, I got it wrong, it's mine. To always tell this story about Kali Yuga and Satyug. The next para. The next line, the rule also applies to any unattached chattel found on the land. The rule also applies to any unattached chattel found on the land, but only if the chattel is found, etc., etc. Then about accretion to land you're entitled. The para 3.01 formula, a little lower down on the page, PDF page 3, an owner can divide the land horizontally or any way he likes. He or she can dispose of the minerals under the surface or on the top of a floor of buildings to make them separate properties. But unless some contrary intent is shown, the grant will normally pass the owner's whole interest in the space above and below the land. Thus, for example, a lease will give the tenant a right to the airspace above the landlet, etc. Now, this is the general law. And this law also applies in India, except where there has been a statutory intercession.
The lease will give the tenant the right to the airspace above the land.
Correct. Also minerals.
So if he wants to fly kites, he can do so.
He can, but not planes. The law, my lord, in India is also the same. And we get that, my lord, from a judgment of this court in Jacob and Geologist, Department of Mining. (2013) 9 Supreme Court cases. Page 725. I'll come to that judgment in a moment. Your Lordship can just note it down. Here. And that's in bundle 5A, page 831. I'll come to that in a moment. Therefore, my submission is now look at the collocation of interest. Because of this peculiarity, as Gopalan explained, of Indian law, how it is evolved, we took out mineral rights and says tax on land revenue and mineral rights. If the three are understood in the same sense, then everything falls into place. Today we have, where Parliament is almost nationalized and federalized, the entire system. And for good reason. The economic impact, and the solicitor is going to deal with that. Your Lordship will see, it's huge. If the price of iron ore goes up, Indian steel disappears from the market. We had reached a point, my lord, when at one stage, because of all the environment problems, when Goa closed another mine, then your Lordships dealt with those applications. People said, we'll import steel. The import of steel had to open, because if you don't allow steel, then other downstream industries start closing. You can't starve the country of steel. And steel became priced out because some of the mines closed for environment reasons. And then Indian iron ore got priced out. And then Indonesia enters the market. But today, in one sense, the world has become a very small economic space. And that is why this tight control. You can't fiddle with any one element of this economics, but the whole picture gets distorted. It's like a jigsaw puzzle. So, my lord, my submission is, if it is construed in the same sense, then, my lord, a lot of this also falls away. I've made the point, my lord.
So if you construe it in the same sense, what is the sequitur then?
Well, what if therefore, then, my lord, where there is an ownership, and in exercise of that ownership, mineral rights are exploited, you of course can tax them. So if today, my lord, there is a very sliver left, but there is still something left. Some private owner giving it, earning royalty, the state says, look, I don't get any share in this. You as a private owner are exploiting mineral rights, maybe you're following some rules. I don't know what I'm not appearing, but I can see the point there that you can tax this. But where, and that is why, my lord, it's very important. Our law has always treated from 49 state ownership as a separate chapter of the MMDL, where the mineral vests in the state. It's for this reason.
So according to you, tax on mineral rights cannot be imposed where that minerals vest in the state.
West in the state itself is creating the mineral rights now as a delegate of parliament, as it were. That's the point. Now, what happens then to the taxing entry? And I have to deal with logically at this point, so that we are done with entry 50. What I call the Kannadasan conundrum.
What happens if the mineral rights, of course, vest in the state, albeit in recognition by an act of parliament, and the state farms out those mineral rights?
If the
Can it
state,
not, or it farms out some portion of the mineral rights? Can it not impose a tax? Because it is acting in a dual capacity. In farming out the mineral rights, it's acting as the owner of the minerals. In taxing it, it's exercising its sovereign power of taxation.
the problem is, if the tax on mineral rights is conceptually the share of the state in the mineral rights, or the share of what the owner earns from the mineral rights, then once the rights are with the state itself, what it earns is by farming out those mineral rights.
Right, but the state is farming out those mineral rights. When it farms out the mineral rights, can it not extract a share in what the private person or the third party earns from the state by saying, I'll tax that? Because taxation it doesn't have a logical basis. Taxation is always, it's really in that sense a fiction of the law, right?
Malad, I see the point where if tomorrow the state was acting purely in a contractual capacity and wearing two hats, one the sovereign taxing power and one as a contracting party. Today it doesn't do that, but tomorrow if it were to do that, and it was left free to do that, there may still be a conceptual problem. And let me just state the point. I don't want to overstate it. Let me just state the point. If I'm right in my understanding of the collocation of the three entries, 45, 49, 50, a tax on mineral right is where the state is taking from the owner a share of what the owner earns. Now the state, when the 100% vests with the state, there is nothing to take. What the beneficiary of a lease then gets is what the state has bestowed on him. There is no further share. That's it. Now, my lord, I've finished. One last bit remains. It all goes back to the nature of the tax. Now, my lord, I come to the last limb. Your lordships had asked, and it's a very important question to ask. If we are right on especially the first limb of 50, that assuming the state could have taxed even where it creates rights, etc., the limitation is what takes away the right of the state to tax. And what happens to the taxing power? My understanding of the Constitution and first principles will be the taxing power sits where it sits. It doesn't vest in Parliament. But there is a view taken by this court that it does. By two judges, I must show that judgment. How far it goes and how far your lordships find it of assistance is quite another matter. This is volume 5C, page 114. Your lordships will, of course, read the judgment. Let me just tell my lord what this judgment is about. In 1991, after India cements, all the states face the prospect of making refunds. And a question arose, where is the money going to come from? So, Parliament brought a validating this. That law was challenged on various grounds, including legislative competence. 124. Let's see. The first ground, Malad, on which most of the attention was bestowed doesn't need to trouble us today, because that was on the ground of usurpation of judicial power, whether there was a proper validation. Put that to one side. The union there relied on Jawra sugar, para 27, which your lordship will find at page 136. And Jawra sugar was where the state imposed a tax on sugar cane entering the factory and sought to justify it as a land revenue. Your lordship struck it down saying sugar cane entering a factory is not in the ken of the state. It's not in list 2. Now, if it is not in list 2, Parliament can always make that tax. So Jawara Parliament validated that. Your lordship said, we held it is not in list 2. If you hold it is not in list 2, Parliament can always validate.
Then it is as if it is deemed to have been imposed by Parliament there.
Yes, and by 97.
That's right.
Now, relying on Jawara, this law is upheld. Here it is not that it is not in the state list. Here it is in the state list but subject to limitation. So what happens to this taxing power till those limitations are in play? That unfortunately is not addressed squarely, but the judgment, since it deals with the question of legislative power, your lordship, I thought your lordship should see this. Para 27 at page 136. The validity of the sugar cess cane validation was questioned in Jawra. The contention of the learned counsel for the appellant petitioners is that if Parliament wanted to impose the levies which were earlier imposed by state enactments were declared incompetent, Parliament must impose the levy as has been done by Section 3 of the Validation Act, etc. Now that was one, Malad, that's more on the form of how the validation should have been brought in place. The third contention, and Malad, where we really come in, fifth, page 141.
Yes.
Para 34 and 35. It is argued very idea behind MMRD was to bring about uniformity in taxes, royalties. It's true, that is. But that doesn't mean Parliament cannot create an exception. Uniformity in rates of tax is an objective set out in MMRD Act. It is not a precondition to a law made by Parliament under 51, nor a limitation on Parliament's power. If Parliament is enunciated, the principle also create an exception, precisely what has been done in the instant case. The impugned enactment is both an addition and exception to Section 9 of the MMRD Act. Now, this is very important. So they now brought 9 and tax on par. The fifth contention of the learned counsel for the appellant's petitioners is equally misconceived. Parliament has already denuded the legislature of their powers to levy tax on minerals, inhering in them by making the declaration contained in Section 2 of the MMRD Act. Now, my lords will know why I'm coming to this judgment towards the end of my submission. I have not relied on the declaration. I have not put my points on a slightly different footing. But this is how this court has seen it. Shri Sanghi argued. So I will just pause here because, my lord, now let me tell, my lord, quite candidly what I'm driving towards. I'll tell, my lord, why, honestly, my lord, I'm sorry. I'm at the end, my lord, going to suggest one way out of this, what I call the Kannadasan conundrum, is that 7 judges held a particular way. That was acted upon, it came to rest. Yes, sir, I made a mistake by unsettling that position. I am coming to it in the end of my submission because I wanted to first satisfy your lordship that on principle also we are right. But if that is done, then all this landscape need not be disturbed. But if one tests each proposition here, we don't know where this is going to end up. Because this is pulling all the strands apart. But just see how your lordships put it. Shri Sanghi argued that the denotation is not absolute, but only to the extent provided in the MMRD Act. Section 9, Council submitted as one of the facets of the extent of denudation. 9, it is submitted, sets out the rates of royalty. And also the states rates of royalty can be revised if Section 9 is to be amended to the directly or indirectly a fresh declaration in terms of entry 54. This contention assumes that notwithstanding the declaration in 2, the states still retain the power to levy taxes on the minerals over and above those prescribed in the MMRD Act, and that a fresh declaration is called for whenever such subsisting state is so and so. This supposition flies in the face of the decision of India Cement and Orissa. The decisions are premised on the assumption that by virtue of the declaration, the states are denuded of the power to levy taxes. It is for this reason that the state enactments were declared incompetent so far as they purported to tax cesses to minerals. The denudation is not partial, it's total. It cannot levy any tax or cess on minerals so long as the declaration in 2 stands. Once the denudation is total, there is no occasion or necessity for further declaration or denudation or for repeated declaration.
Mr. Salve, perhaps the problem which confronted the bench was that India Cements was binding on them.
Yes.
They were a bench of 2. They had to take India Cements as it is. There was a validation act, and there was a challenge to the validity of that act. So when they formulated whether the states are denuded the power of imposing taxes on minerals,
The area is, if there is a limitation made by Parliament, Parliament can limit the state's taxing power. Can Parliament exercise that taxing power? And a question which your lordship asked right from the beginning. Where does Parliament get the power to lay this tax? And if Parliament doesn't get a power to lay this tax, they can't validate this tax. Now, that's a conceptual problem. And this judgment goes on the footing that because the states can't, the Parliament can. That's all. It says there is no discussion.
because if denudation is right, that field is not shifted to Parliament. It's just that the states lose it. Except then that they would have, if it's a denudation, possibly, if it's a denudation of the power of the states under entry 50, and conceivably, it might then go to entry 96.
That can be the only.
Entry 97,
That can,
including a tax not falling in any of the lists. Of course, entry 97 covers an area where the subject does not belong to any other entry. Here the subject belongs to an entry But that subject is denuded from the power. of the
The
state.
language of 97 will have
97 is very different.
serious problems
Yeah, that's
because
right.
it says any tax not mentioned
Not
in any of
mentioned in
This is
list one
mentioned
or list two.
mentioned but limited.
but limited.
Now, conceptually, how it flies,
It's just still in.
And nobody has challenged all those provisions for the district mineral fund and everything. So
Nothing.
then all that will come into very serious difficulty. Apply prospect. Upheld prospectively.
this malad was followed up in another judgment. Just see that one, 2001 7 SCC 358, volume 5E, page 2. I am not, malad, inviting your lordship to reverse this. Please don't misunderstand me. I only said this is the Kannadasam conundrum. And to complete my argument, I must show these. No, it's not reversed. Malad, this judgment held, Malad, I'm sorry, it is in volume 5E, page 2,
5E.
where 3 judges heard. They did not reverse the principle of the law. They only said this cannot apply to future recoveries. It only saves the past.
Tell us the page number once again.
I'm so sorry, Malad. This is in volume 5E, page 2. Conundrum note. And in this, Malad, Kannadasan principle is upheld, but they said this cannot apply to future recoveries. And that discussion your lordship will find. Page 35, sorry, of the PDF. Now. The discussion, Malad, in fact, begins at page 34, Placitum C. Parliament never conferred any right on the state government to make any levy or collect cess which has not been collected or collectible. Parliament merely conferred life to the void statute by fictional reenactment. And please mark the words, granting legislative competence for the limited purpose. So that the state would not be called to refund the cess already collected, and the circumstances do not find much fault in the contention, Mr. Dwivedi, about the enduring nature of the law, and we hold the provision of the state laws, which are validated under the Act and were alive till 4/4/91 having expired. There is no authority under the law which the state could raise any demand. The conclusion in Kannadasan to the contrary, therefore, must be held to be not correct. Orissa Cement, the court, though declared the levy of cess to be unconstitutional, further directed there will be no direction to refund any amount collected until the date on which the levy in question has been declared unconstitutional. This date, so far as Bihar is concerned, with the date of the judgment 4/4/91, in Orissa it was 89, in Madhya Pradesh it was 86. It was held that any cess collected after the dates by the respective states has to be refunded to obviate the aforesaid difficulty, particularly Orissa and Madhya Pradesh. Though the difficulty is not there in Bihar, Parliament came forward with the Validation Act. It is true, as Mr. Dwivedi contended, that contended that there was no necessity for including the Bihar Act since Parliament was enacting, but since several state laws were reenacted up to the date of the judgment, thought to have fitted the legislation effective, but for a limited purpose, so the state would not be liable to refund any tax. We find sufficient force in the contention of Mr. Venugopal that the law never existed after 4491 and consequently so and so. And my lord, that is dealt with. Then again, para 21, around just below placitum F, my lord. After citing Jawara, it says Dr. Singhvi is also right in a submission that this court in Kannadasan drew a wrong analogy from Gangopadhyay and erroneously held provisions therein identical to the Validation Act. To one of the Validation Act having used up to 4491, it is unequivocally indicates what is validated the process of levy and collection up to that date.
So they overruled Kannadasan.
To this extent. But the basic principle is upheld. The validation is upheld. Only said it's validated up to 4491. Now, quite frankly, my lord, if it is completely lacking in legislative competence, only way to do it is to dilute the limitation, but not Parliament imposing the tax. What they've done is Parliament imposing the tax. That's what Kannadasan upheld, and that was upheld. The district mining officer case doesn't go back on that. That's the point. About 50. I'm done with entry 50. But there are some more cases about denudation, etc. If your lordship permit me, in the closing written note, I'll give the passages in those citations.
Certainly.
There's some other ground which I need to cover today.
Yes, Mr.
Now, my lord, the next point. If I'm right on 50, does 49 help the state? It can't, in my submission. The point is simple and short.
That's your decoupling argument.
So one thing is then clear.
That land tax on land, according to you, cannot include tax on mineral rights.
So that's very clear.
But they would argue that
The measure.
that's a measure and not the levy.
So I come immediately to the measure.
Is on land.
That's why I said the first part is easy, and one must construe 49 and 50 in separate compartments. Because 49 is on one aspect of land, 50 is on another aspect of land. We can't mix the two. Sorry, I shouldn't use the word aspect. It has created a lot of confusion in our constitution. 49 is on land, 59 is on mineral rights, which are not a part of land anymore. It took my lord 5 of your lordships to exorcise the ghost of the Canadian aspect theory in luxury tax. So let's not go there again. 49 is tax on lands and 50 is tax on mineral rights. Now, why is tax on mineral rights separate from tax on land? The decoupling argument. If something is not a part of land, how can it be a measure for a tax on land? That machine, tax on machine, this is nothing new, man. Your lordships have dealt with these problems. Tax of machines, value of machines. Can you add that to the value of land for a factory? You can't.
But Mr. Sarve, when there's a challenge to the validity of a measure,
Yes,
as opposed to a challenge to the validity of a levy,
yes.
the test is not as strict, so long as the measure has some broad nexus with the
Absolutely.
character of the levy, it is sustained.
Correct. Now here I'm saying the character of the levy here is on land. Anything which has a nexus with land, but something which has been removed from the land. Legally, conceptually. How can it provide you a measure? And your lordships have dealt with this. Machinery. Machinery is fixed on land.
And again, what has been removed, assuming that entry 49 does not include mineral rights, and
Yes.
that may be plausible because
Yes.
once there's a separate entry, you can't
Yes.
read that entry into entry 49.
Exactly.
So we proceed on that postulate. But entry 49, when it speaks of tax on land, that refers to the levy.
Yes.
So long as the levy is on land as a unit,
Yes.
the legislature has a wide discretion to choose amongst various alternatives for determining the measure on the basis of which the levy can be imposed.
Far too well settled to argue.
And insofar as that measure is concerned, the measure need not be a measure in the constitutional sense,
It has a nexus.
so long as it has a nexus.
Now, my lord, where mineral rights are legally a class apart, they are no part of the land. How do they then have nexus with the value of the land? That's the point.
All right.
If I use, my lord, land for parking aircrafts, can you say the cost of the aircraft will be my measure for taxing the land? You can't. You can say the rent you are getting for parking the aircraft, that I will take. But can you say I'll add the value of the aircraft to the value of the land and 5% of that? You can't. The necessary legal nexus is missing. If I'm right, in the first part of my argument, that there is a decoupling. I am the owner of the land. I have zero right to mineral. And the owner of the mineral has zero right to my land. The state owns the mineral, I own the land. You are telling me I will tax you on the land on what basis?
You know, Mrs. Sarve, actually, this may not be a correct way of reading the purpose. Both entry 49 and entry 50 give complete and exclusive jurisdiction to the states to impose a tax on land and a tax on mineral rights. Absent entry 50, a tax on mineral rights would have been comprehended within entry 49.
Yes.
Right? Now, the reason why they decoupled, so to speak, entry 50 from entry 49 was because they wanted to subject a tax on minerals to the limitation imposing power of Parliament under entry 54 of List 1. Otherwise, it's not as if the power to impose those two taxes are given to two different legislatures.
Let's test the first.
The legislature is one and the same.
Sorry, let's test the first part. Let's test the first.
Yes.
Let's assume 59 is not on the statute.
What is not?
50. Let's assume 50 is not on the statute. There was a tax on land and buildings. I own a plot of land on which I have made a house. And it is found that under my building, there's iron ore. Can you include that in my value? No, because that doesn't belong to me. It can't be a measure for taxing my land.
But if the ownership of the
If
mineral.
the ownership is in me, of course it does. So if I do not own the mineral, you can't tax it as a tax on land. A statutory lessee has no right to land. If I am right on decoupling, surface rights, of course, you can tax. Surface rights, as we very carefully call them. The surface rights ex hypothesa are not rights to the mineral. Today, my lord, we all own homes. Who knows what you find under our homes? Today, my lord, there are minerals which are found which till yesterday were considered worthless, today may become very valuable. With fracking, my lord, who knows who has oil under their house? Now, do any of us own it? No, because we only have the right to live on the land, or if you have a big tract of land to do farming, to do whatever, your land for whatever surface purposes. You can park your cars, you can give it for parking aircrafts, you can give it for parking trucks, you can do it for whatever you want. And whatever I earn out of that, whatever is the capacity of that to yield income, any facet, you can use any of that as a measure. Of course. But some right which I do not have in that land, do not have a right to anything which is below that. How can that be a measure for taxing me on the land? Conceptually. And your lordships have dealt with this. So, wherever your lordships have held, let's take the land cases. The capacity of a hereditament to yield income, Raliara. I own a house, I may not give it on rent. Does it have the capacity? Of course, it has the capacity, I can give it on rent. If I am allowed to own, as in the Jacob situation, I own 50 hectares, which has a minor mineral in it, the Jacob situation. And somebody says, I will tax you on that basis. Of course you can. You can tax me in 49, saying land, including the capacity to yield, subject to my 4950 argument. I'm on the measure. But if there has been an effective decoupling by which I have zero right, title, or interest to the mineral, that mineral is no longer part of land. That mineral in law has ceased to be part of land. I'm the owner of the land. Is there any doubt? No. I have full title to the land. But my full title to the land doesn't mean I have a right to exploit the mineral. Because minerals as a separate head have vested in the state. How can that be a measure of a tax on land where the minerals are vesting in the state? Where they don't vest in the state, yes, sir, a different consideration. And that is where, Marad, the measure breaks. Because then it has lost nexus with the land, it has lost that connection.
You're relying on RR engineering and then.
RR and Bombay Tire. At which point you levy, how you collect, everything, you have full latitude.
Let's see RR and then Bombay Tire, how it's put there.
And Malad, in fact, also a recent case.
2013.
Yes. Where,
Sorry, 2021.
Yeah,
That-
21
that
in
Customs
ASA.
Act, ASA, Customs Act.
Yes. May I just show that those one or two cases, Malad? Because this is another. Malad, volume 5F. Is RR Engineering, page 24. And if your lordship, my lord, permit me, I'm trying to come straight to the relevant paras, my lord. Para 16 at page 6.
Page?
Page 6, my lord, para 16. I'm reading the bits which they rely on and then the caveat which I rely on.
What's the, sorry, what's in volume 5F? What is the page actually?
Page
Page 24.
24. Oh, I'm so sorry. This will be page, para 16 will be on
Page 30.
page
Para
30.
16 will be at page 30. PDF.
30. I'm sorry, Mara, later on to upload it so the
Yes.
pagination changed. It may be and is so often that a tax on circumstances and property is levied on the basis of income which the assessee receives from his profession, trade, calling of that property. That is, however, not inclusive on the nature of a tax. It is only as a matter of convenience that income is adopted as a yardstick or measure for assessing the tax. As pointed out in a reference under the Government of Ireland Act, the measure of a tax is not the true test of the nature. Correct? No cavil with this. Therefore, while determining the nature of a tax, though the standard on which the tax or levy may be a relevant consideration, it is not a conclusive consideration. One must have regard to the real nature, its pith and substance, which must determine into which category it falls. Applying the test, the tax on circumstances will fall in the category of a tax on a man's financial position, his status taken as a whole, including what may not be properly comprised under the term property and at the same time ought not to escape assessment. Look at this, Marad. If a doctor is taxed on the premise that you are a lawyer, a poor doctor might go bankrupt. The quotation finds place in the judgment of Malik Chief Justice in the full bench in District Board of Farrukhabad. The formulation which learned Chief Justice would appear to have extracted from another source and he is put within courts is similar as Pandit Naram Narayan. Assessee challenged validity to pay tax on circumstances and property in 14(1)(f) on the ground he did not reside in the jurisdiction of the town committee at Karan. And under Rule 3, it was invalid. The court, after referring approvingly to Farrukhabad, particularly to the statement given to the tax did not matter, not had to be considered the pith and substance. That, my lord, is that, please see para 20, page 32. Entry 49 of list 2 refers to taxes on land and buildings, while entry 60 refers to tax on profession, trades, callings, and employments. Having already considered the true nature of a tax on circumstances and the property whereof the opinion in any event and at least referable to 49 and 60, the profession, trade, calling, and employment which the person occupies, and the land and building which, please mark, my lord, which he owns, determines the status which he occupies. The impugned tax is the composite tax, one of its components being the circumstances of the assessee. By circumstances is meant his financial position, his status as a whole, which depends on the income from lands and buildings. It is that view which was held by a full bench of Allahabad and Muzaffarnagar and Jugal Kishore. Barun Jay, who spoke for the court, observed it is clear from the very nomenclature of the tax, it was on composite character, etc. etc. Then, my lord, your lordships cite the usual cases. And para 22 is where, my lord, for the first time, the red flag is raised. While doing so, we would like to utter a word of caution. The fact that one of the components of the tax, that is the component of circumstances, is referable to other entries should not be construed as conferring an unlimited charter on the local authority to impose disproportionately excessive levies who are subject to the jurisdiction. An excessive levy on circumstance will tend to blur the distinction between a tax on income and a tax on circumstance. Income will then cease to be a mere measure or yardstick of the tax and will become the very subject matter. Yeah, my lord, you say 50% of the royalty you pay breaches this principle also. I mean, you levy the same tax and the mineral tax. You say it fails, okay, how about entry 49? As the measure. You can't hop from one foot to the other like this. And this, my lord, was cited and forms the basis of Bombay Tire 84 1 SCC 467, volume 5A, page 251. Page 262, my lord, para 9 sets out the contention of the union. See the last 7 lines of para 9. According to him, although excise is a levy on the manufacture of goods, it is open to Parliament to adopt any basis for determining the value of an excisable article, and that the measure of assessing the levy need not correspond, please mark the words carefully worded, completely to the nature of the levy. And no fault can be found with the measure so long it bears a nexus with the charge. And this test, my lord, is discussed fully, page 14, para 14 on page 265. I'll just read these 3 paras and then I'm done with this point. We now move to a different dimension to the conceptual consideration of the measure of a tax. Section 3 of the Excise Act provides for the levy of excise. It charges the charge, it creates the charge and defines the nature. That is the levy on excisable goods produced or manufactured in India and mentioned. Section 4 provides the measure by reference to which the charge is levied. The duty of excise is chargeable with reference to the value of the excisable goods, and the value is defined in express terms. It has long been recognized that the measure employed for assessing a tax must not be confused by nature. Then, my lord, the famous Ralaram, where the tax on lands. Over the page, my lord, is Atmaram Budhya, where a tax on passengers was assessed as a rate on fares and freights payable by the owner. Clearly, my lord, there is an excess. The court repelled the contention that the tax was a tax on income. It pointed out though the measure of the tax is by the fares and freights, it does not cease to be a tax on passengers. If I may just pause here for a minute, my lord, in all these cases, your lordship will find the challenge was not that there is no nexus. The challenge was this measure actually makes it a different kind of a tax. So if you put it on the income I have from fares, it becomes an income tax. Or if you put it on the rent, then under the Income Tax Act also, the annual letting value is income. So it becomes a charge on income tax. So the nature of the tax undergoes a change. Your lordship said no.
See page 267, the last para, it is apparent therefore.
Yes, my lord. And after RR is cited,
They cite IRR.
RR Hingir Rampur, and then, my lord, last 3 lines puts it prettily. Any standard which maintains a nexus with the essential character of the levy can be regarded as a valid basis for assessing the measure of the levy. I accept this. I'm saying please apply this in the context in which I have put it. And my lord, one important case which goes the other way in our favor is 2004 8 SCC 173 A sir.
5F, page 2.
It is volume 5F, page 2. Question was, my lord, set out in para 5. What the commissioner held is that the value or the cost of the operational software installed by the assessee on computers before clearance is included in the assessable value. Para 21 onwards, my lord, and page 15. Sorry. Yes, page 11. I'm not going to read them, my lord. There's a full discussion. Then the interpretation of a taxing statute. Then, my lord, the discussion begins from para 51 at page 15. So your lordships, my lord, trace this. And para 55 is what I rely on. Because we borne in mind central excise cannot be equated with sales tax. They have different connotations and apply in situations. Central excise is chargeable on excisable goods and not on goods which are not excisable. Thus, goods which are not excisable, if transplanted into goods which is excisable, would not altogether make the same excisable goods so as to make the assessee liable to pay the excise duty. Excise duty would be leviable on goods which answer the definition of goods. A machinery provision in 4, and that too explanation, by way of transaction value, can neither override the charging provision nor by reason thereof goods which is not excisable, this is the principle, would become excisable only because one is fitted into the other. This was considered again, Malad, in 2018 7 Supreme Court cases. (233) Grasim, where they went into tax and measure. And Malad, page 926 onwards.
Of volume?
I'm so 5A, Malad. Starts at page 909, where Bombay Tires is reiterated. And para 17 makes important reading. Your Lordship, Malad, turns to para 17 at page 926. The measure for the purpose of the levy is the price charged in respect of a transaction which must necessarily be arm's length. Included in the additions that enrich the value till its clearance are permissible additions to the price which can be taken into account to determine value, the whole as well as the transaction value, which under the amended section so and so. While such additions have been judicially held to be permissible under the old act, the very same heads are statutorily engrafted by the amendment. The price charged for the manufactured article at the stage when the article enters into the stream of trade in order to determine the value of the transaction for computation of excise does not come into the essential conflict with the essential character or nature of the levy. The measure is the value, and the value is related to price. And the price is charged at the stage of clearance. And that's how your lordships upheld it. And what other passages are cited? The attempt was to say Bombay Tires is wrongly decided, your lordship said. And para 23 is important. 929. Para 929, page 929, para 23, where Acer is dealt. This would bring us into consideration of the decision of this court in Acer. The details need not detain us. Software which are duty-free items and could be transacted as software came into become combined with the computer software which was the dutiable item for clearance. The revenue sought to take into account the value of the software for the purpose of transaction. The court negated the stand of the revenue, taking the view that when software as a separate item was not dutiable in the inclusion in hard disk, the computer cannot alter the duty liability so as to permit the addition of the price value of software. It is understood that the decision in the context Acer has to be understood. The observation in para 84 to the effect that the transaction value would be subject to the charging provision will have to be viewed in the context of a situation where the value of a non-dutiable item was sought to be added to the value of a dutiable item for purpose of determination of transaction of the composite. This is the limited context in which the subservience of 43D to 3 was expressed. If so understood, we do not see how 84 is in conflict with Bombay Tires. So 5 judges upheld the Acer principle. You can't tag something, and here it's worse, Manoj. Here I don't even own that. I mean, I've made the point. We don't even own those minerals. Excuse me. Item number 16, serial number 16. Now, my lord, Murthy. Let me very quickly deal with why I say, therefore, Murthy is wrongly decided and was rightly overruled in India Cement. Murthy's item number 60. In volume 5, page 296. Oh, I'm sorry, page 302. Ah, yes, I've got it. Now, my lord, in this, Hingir Rampur is citing, because what they had done is by defining royalty as part of land cess, it was done. Page 301, para 9. I'm sorry, page 307, para 9. It will be seen there is no resemblance between the provision of the Orissa Act and the two decisions for which the cess under 78, 79, which are concerned. 78, 79 have nothing to do, not concerned with the development of mines and minerals. The proceeds of the land cess under 92 are to be credited to district fund, etc., etc. The funds to be used under Chapter 7 with 112 start for everything necessary conducive to the health, safety, education of inhabitants and amenities of the local area, and everything incidental to the administration, including the particular matters which are mentioned therein. First of all, Manoj, now this again is a field which gets squarely occupied by the law. It will thus be seen that there is no connection between the regulation and development of mines and minerals under the Central Act and levy and correction of land cess. With great respect, Manoj, this is too narrow a reading. It's plainly wrong. Because if the Act actually covers this field, then even by incidental encroachment, the area gets covered. Then, my lord, para 10. It was really it was next further that land cess was really a tax on mineral rights. Then, my lord, entry 50 is set out. Parliament and that the central acts also under which taxes and fees might be levied brought into play last portion of the entry. As a result, power to impose the tax was not available after 48 and 57. In this connection, Mr. Ram Reddy pointed out that as the impugned cess was payable only in the event of the mining lessee winning mineral and also paying the royalty where no minerals were extracted, it was in effect a tax on minerals one and therefore tax on mineral rights. We are unable to accept when question arises precise head of a legislative power on which taxing statute has been passed, the necessary inquiry in truth and substance is nature of a tax. No doubt, in a sense, a very remote sense, it has relationship with mining, as also the mineral won from the mine under the contract, on which royalty is payable on the quantity of mineral. But that does not stamp it as a tax on extraction of the mineral or mineral right. It is unnecessary for the case to examine what exactly is a tax on mineral rights, seeing that such a tax is not leviable by Parliament, but only by the state. And the sole limitation on the power is that it may not interfere by a law made by Parliament. Our attention was not invited to the provision of any such law enacted by Parliament. In the context of 78 and 79, it is clear that the land cess is truth a tax on land with entry 49. Under entry 78, cess is occupied on occupied land of whatever tenure. The basis of the annual rent, that is the value of the beneficial enjoyment, This being the basis and disclosing the true nature. And then, my lord, the last line is, when the land is held under a mining lease, that which the occupier is willing to pay is accordingly treated as annual rent value of the property. My lord, this is wrong in law. I don't become the owner of the mineral. It's a lease to work and win mineral. As I don't become the owner of the land, and the decoupling of mineral from land was not an argument presented, and therefore not an argument dealt with. Such a rent value would include not merely surface right, but dead rent as well as royalty. That's the only reasoning. None of the points which I have, my lord, invited your lordship to consider. Copy this. Land says, how can it be on mineral under a central lease? No, my lord, nothing. What was argued was it can't be, and they said, no, if you occupy, you have the mineral rights. But you don't have it as the owner of land. And the minerals vest in somebody. My lord, all these points were not present. Now, my lord, I come to India Civil. And I submit it was rightly decided. It's in volume 5, page 115. Sorry, 1151, sorry, yes.
Volume
5, page 11, it begins at page 1145. Oh, sorry, 1151. I'm off by 6 pages. As I read India Cements, it lays down the following points. I'll try and paraphrase the points and then quickly read the judgment. The first and the most important point it holds is that section 9 of the MMDR caps royalty. And if you impose this tax, you are indirectly increasing royalty. I don't think that point can be disputed. You are. And that your lordship will find in paragraph 23 at page 1165. May I just show that very quickly?
page 1.
In Buckingham, Karnataka, this court reiterated non and held that entry 49 was confined to a tax that was directly on land as a unit. I have not cited all these cases. I can put them in a note for your lordship. So they are all the points which I said on first principle, but they are all the cases I have. Now, if it is land as a unit, the second gift tax officer in Mangalore, Nazareth, held the tax on gift of land was not a tax imposed on land, but only on the user, namely the transfer of gift. That is how they distinguished it. And in Dillon, the court approved non as well as Nazareth. So therefore, land as a unit is now an accepted principle. In Bhagwan Das Jain, the court made a distinction between levy of income from house property, it should be income and house property, etc., etc. It is therefore not possible to accept Mr. Krishnamurti's submission that a cess on royalty cannot possibly said to be a tax or an impost on land. Mr. Nariman is right that royalty which is indirectly connected with land cannot said to be a tax directly on land as a unit. Means a measure of legitimate measure. And this proposition I submit is plainly right. In this connection, reference may be made to the differentiation between the different types of taxes. For instance, professional tax in Western India, it was held that an entertainment tax is dependent on whether there would or would not be a show on cinema house. If there was no show, there was no tax. It cannot be a tax on profession or calling. Professional tax does not depend on the exercise of profession, but only concerns with the right to practice. It appears that the instant case, no tax can be levied if no mining activities are carried on. Now that's the tax under question. Hence, it is manifest that it is not related to land as a unit, which is the only method of valuation under entry 49 of list 2, but is referable to minerals extracted. Royalty is payable on a proportion of the mineral extracted. It may be mentioned that the Act does not use dead rent as a basis. Hence, there cannot be any doubt that the impugned legislation in pith and substance a tax on royalty and not a tax on land. But this is plainly right. This is one dimension. This is entry 49.
Correctly, as far as entry 49 is concerned.
Then, my lord, entry 50 is called into aid. And your lordships accept, if your lordship sees 1, 2, 3, the last 5 lines, even though minerals are a part of the state list, they are treated separately.
Where will you get that?
I'm so sorry, my lord, para 24, page 1166.
24.
Yes.
About 4 lines from.
Yes.
Yes. Even though minerals are part of the state list, they are treated separately, and therefore the principle that the specific excludes the general must be applied. And your lordship cite a case, Waverley and Raymond, where it was held that entry 49 cannot possibly include minerals. These are all well settled principles. And this proposition is further developed in para 25. In this connection, the Attorney General for the Union submitted that in order to sustain the levy, the power of the legislature should be found within one or more of the entries. The levy in question has to be a tax or fee or impost. If it is neither tax or fee, it should be under the entries. The expression land according to the significance has indefinite extent, both upward and downward, and surface of the soil would exclude not just the face, but everything so and so. The minerals which are under the earth can in certain circumstances fall under the expression land. But as tax on mineral rights is expressly covered by 50 of list 2, if it is brought under the head taxes under 49 of list 2, it would render 50 redundant. Attorney General is right in contending that entry should not be so construed so as to make any one entry redundant. It was further argued that pith and substance, the tax fell in 50, it would be controlled by legislation under 54(1). With respect, one, what's wrong with this? It's absolutely right. Well, unfortunately, everybody got fixated with that royalty is a tax, royalty is not a tax. Then, my lord, Murthy is cited. No, I'm sorry, para 27. I'm so sorry. Yeah. रुक जाइए, 1 मिनट रुक यार. My lord, para 27 cites the Mysore case. And please see from third line, speaking for one of us, said that combined reading of 23 and 50 of list 2 and 54 establish as long as Parliament does not make a law of its power under 54, the powers of the state under 23 and 50 would be exercisable. But once Parliament makes a declaration, it is expedient in public interest to make a regulation of mines and minerals. To the extent which such mineral regulation is undertaken by law, the power of the state under 23 and 50 are denuded. The court was concerned with the Mysore Village Panchayat Act. Thus, it was held it could not by the act by passing. The state legislature, by enacting 143, intended to confer power on the Taluk Board to levy tax on mining activities carried on by person holding mineral concessions. It followed levy of tax on by the board on impugned notification unauthorized. At page 306, it was held that royalty under section 9 and minerals was really a tax. It was not really in the nature of a tax. And I have made elaborate submissions, but not on exaction. That's what really it is. If it's a share of the state, it's an exaction. So that's why it is akin to a tax. So the similar effects are the observations of the High Court in state of Bihar. That Malad, actually, that line should have gone above. Then Malad starts Murthy. Murthy is a separate point. And Murthy is cited Malad in para 29. But what is important is just above para 29. The court says, after Malad citing Murthy, this with respect seems to be not a correct approach. It was further observed that it was not necessary to consider the meaning of the expression tax on mineral right flowing from entry 50, inasmuch as according to the court, Parliament has not made any tax. This is not a correct basis. And with respect, their lordships are right in saying so. Then Murthy is cited. And para 30 says, it seems therefore the attention of the court was not invited to the provision of the MMDR and section 9 and 9.3 in terms states that royalties shall not be enhanced more than so and so. Therefore, a clear bar on the state legislature taxing royalty. So as, Namalat, please mark these words if your lordship don't mind. In effect, amend the second schedule of the Central Act. This is what, in my submission, really, is the heart of the matter. Then what happens to the limitation? My Lord Justice Pardiwala was pleased to put to me, look at 9.3. Then all this 9.3 and all is of so much academic use. And if this is, my Lord, the proposition, I submit this is clearly right. And there is no typo in this. in the premises, it cannot be right to say that the tax on royalty can be a tax on land, even if it is a tax on land, it falls in entry 50, will be ultra virus. In Hingir Rampur, then not Hingir Rampur, that what happens is Mr. Justice Vanchu says it's excise duty. Now, for that, the last 3 lines, it says on that basis, please mark the word that basis, a tax on royalty would not be a tax on mineral rights and would be outside competence of legislature. So the fallacy in Mr. Justice Vanchu, on the one hand saying it is excise duty, but in the next breath saying royalty is a tax on mineral rights is brought out here. It's not that your lordships are saying royalty is not akin to a tax. There's no typo here. This is the criticism of Vanchu J's dissent. Then the next paragraph. It is contended by Mr. Krishnamurthy, state has a right to tax minerals. Further contended, tax will not be irrational to correlate to the value of the property and make some kind of annual, etc. In view of the provision of the Act here is the MMDR, as noted, this submission cannot be accepted. And then they refer to 9.2 and said this field is fully covered.
34 is important.
34 is very important. In the aforesaid view of the matter, the aforesaid view is para 32, the limitation and the effect of the MMDR Act. Your lordship say that we are of the opinion that royalty is a tax and such a cess on royalty being a tax on royalty beyond the competence. Because tax in the sense of being an exaction, this may not be the best way to express it.
Yeah.
But it was said in that sense. This phrase, tax on royalties, has become over. Yes, straight away, Mark. As I read, I'm sorry. Yes. Yes, Mark, immediately. Yes.
On royalty, being a tax on royalty.
Yes.
Is beyond the competence of the state legislature because Section 9 of the Central Act covers the field and the state legislature is denuded of its competence under Anti 23 of List 2.
Now, why does, I'm sorry.
In any event, how do you construe these words?
Yes,
In
there are two
any
separate.
event,
Yes.
we are of the opinion that cess on royalty cannot be sustained under Entry 49 of List 2 as being a tax on land. And then in the same breath, court says, royalty on mineral rights is not a tax on land, but a payment for the user of land.
Yes, straight away, Malak. May I answer? There are 2 separate parts to 34.
Correct.
And unfortunately, they got telescoped. For purposes of Entry 49, where the tax is on land as a unit, royalty is a measure of an exaction by the state for the user of the land in the sense for mineral rights, not for land as a unit. So the 49 logic is separate. Unfortunately, the 49 and 50 got mixed up in para 34. Because I have to answer 2 cases. Is this sustainable under 50? Is this sustainable under 49? And that's why, Manoj, I have compartmentalized my case very clearly on 50 and on 49. As far as 50 is concerned, I had made two broad submissions. One is, Manoj, a little wider, which is picked up in that one sentence. You can't indirectly get past the MMDR. Now, we had argued this elaborately on this very premise, that this is a complete tight coded act. We are right or we are wrong, but that's really what was upheld in the earlier paras. So this is indirectly jacking up. It's you are revising royalty rates. And therefore, this limitation is perished. And your lordship will also mark the Attorney General's arguments, which are cited with acceptance. That you can't do it because this is limiting. So, my lord, that is really the answer to 50. The answer to 49 is different because the tax is different. It's a tax on land. The one aspect which I put before my lord is not reflected here, the decoupling point. That's not reflected in so many words. But what your lordships are saying is tax on land as a unit, the non-principle, SC non-affirmed in Dillon. If it is a tax on land as a unit, the state saying royalty for use of the minerals, how is it a tax on land as a unit? That's the last sentence. Unhappily put, I accept that. So, my lord, there is a separate answer to entry 49. There is a separate answer to entry 50 because the two taxes are different.
If under paragraph 34, the expression royalty is a tax is substituted by the expression royalty is an exaction, then that conundrum would go automatically.
Exactly, a tax in a loose sense.
Section 9 has automatically, it has already encompassed within itself imposition of royalty.
That's it. And that is really the heart because one has to read the earlier paras also, where the court has developed this at length. You can't have exaction twice over. I had, my lord, written out, and I'll polish it and give it, my lord, a note on my understanding of India cement. And how there is a little mix-up here and there of different para, but there is no contradiction into that on the essential features of the point. Unfortunately, my lord, the spotlight has shown on this one sentence, royalty is a tax, royalty is not a tax. At one place they say it's a tax, one place they say it's not a tax. Let's add the word cession and correct. That's not the way to do it. But in any case, 9 of your lordships have heard this now and heard this at length. So ultimately, in one sense, none of this really is of assistance beyond a point of understanding what exactly went on.
And also in paragraph 34, there is no reference to entry 50.
Yes, that's only in the.
They refer it only to entry 23. No, in this.
So, my lord, to conclude, therefore, and I must stay within my time. My lord, I'll stay within the discipline of my time. There are a number of judgments which I will put in a note because those. My lord, at two places, para 32, 33, which I have read, entry 50 is expressly dealt with. It says in view of the aforesaid. Now the aforesaid is para 32, 33 where entry is expressly referred to. Entry 50.
They said field is covered by the central legislation.
That's the
By
heart
virtue of section 9(2), and therefore the provisions of section of entry 50 are not attractive.
That's the heart of the judgment.
32, they say that.
That's the heart of the judgment. There are two broad principles in Kesoram. I don't need to read them. Let's forget all this. Do your lordships find, my lord, I come back to, I'm closing in 2 minutes. Because I must stay within my time. Do your lordships find that there is the test of any limitation by a law meant for mineral development? Is that satisfied? If the answer is no, then the right is untrammeled. If the answer is yes, then the right under entry 50 or the power of the state under 50, they would feel to that extent stands denuded.
So you have really argued the matter of first principle now, and we are sitting in a combination of 9.
That's why, my lord, I didn't want to spend too much time on this. The second is, my lord, my point on what is tax on mineral rights, the construction of the entries in concept. If I win on either of those, we are right, and if we fail on both, then none of this field is available to us. I would only close by saying one thing. Your lordships have always applied a broad and massive test to a measure. A broad and massive test. Not a pinpointed, narrow, focused beam. But equally, your lordships have to be sensitive, in all humility, I said, to the compelling needs of the development of minerals in today's India. The solicitor is going to give your lordships facts and figures. Today, my lord, fiscal impositions, and I'm deliberately using a colorless expression, fiscal impositions on minerals as important as those which your lordships find in Schedule 1 can distort the entire development plan of the country. And why I say distort? Because it's not uniform. If Parliament imposes something, it's uniform. Parliament knows I'm adding this burden. Doesn't matter whether you're in Tamil Nadu, or doesn't matter whether you're in Orissa, or doesn't matter whether you're in Bengal. And revenues are distributed uniformly, either directly or indirectly. But by not allowing a overbroad elbow room in entry 49 through the device of a measure being broadly equivalent, or through 50 by reading limitations narrowly, will not, in my very respectful submission, run counter to the legislative intent of MMDR 57, but also to the vision of the founding fathers, who recognized that it is extremely important that minerals, as against land, minerals should be controlled by the union. I am not finished. One last point I need to make, unrelated to this. Now, there is a question of royalty on oil and tax on royalties on oil. There is one a bigger question that arises. If in entry 1, oil is treated separately from minerals, in entry 2, will minerals include oil? That's a huge point, but nobody has dealt with it. I don't know whether your lordship, it's not a question refer, and I don't know whether your lordship would even want to enter that field right now. But Mala, that private oil company shouldn't be allowed to hijack this reference. What is getting its question?
Only a minute. Lord, the Ministry of Petroleum and Natural Gas has said two things. Apart from others, I'll advert to that. That petroleum and natural gas is covered under entry 53. It has no, my lord, corresponding entry, my lord, in the second schedule. Number one. Number two, it is also covered by a
We are not inclined to widen the reference. It's a reference before 9. We also
there's separate enactments also, like MMRDA.
we go into issues.
MMRDA is a different legislation.
That private oil company wants to hijack this
No.
declaration GST.
No, Lord, unfortunately, I'm not trying to hijack anything. What happened was section 6A is identical to 9. What your lordship holds in 9 will apply to 6A. There is no difficulty.
We'll decide the issue in reference. We are not going to go into broader issues.
Yes,
Don't
my
take
lord,
it
your lordship may deal that
without a
separate.
proper canvas without
Yes.
proper argument.
No, high courts have not dealt with it.
That
Forget
one.
benches of this court.
No, I'm not trying to hijack anything. I've just only said of 6A. If your lordship doesn't want to hear it, it's perfectly fine. I only wanted to say that 6A is similar to 9. What your lordship holds in 9 will apply to 6A, number one.
Yes, argument for an
Somebody
appropriate
will have to
basis.
decide.
Oil field issue has come to your lordship's by way of a transfer petition.
Yes.
The special appeal is still pending in
Lord,
the
as a
Assam
ma-
High Court, but that has been transferred here.
So we'll send it back to the Allahabad High Court.
Yes.
Not Allahabad, no,
Then?
Assam.
It's Rajasthan and Assam.
My lord, as a matter of fact,
Mr. Dwivedi, I was also taken by the fact that you are appearing.
I'm appearing as a respondent. I didn't touch upon it because I didn't know whether lordship will be inclined to hear
Lord, as
it.
a matter of fact,
in any case-
MMDRA starts.
Transferred petition. We should know.
In any case, Mr.
Lord,
Qatar is to open on that, so I.
Lordships may, my lord, keep it here. Let it be decided here. My lord. There is no difficulty. 9-judge combination may not examine. The entry is different.
So just
Act
remind
is
us,
different.
we'll delink that transfer petition.
Yes,
That,
just wait for a minute, Lord.
Then that bench will decide
Yes,
to
Malak.
send it back to the High
If
Court.
your
or what-
lordship,
Correct.
No, Lord, I'll just submit. Lordship will just wait. I'm not going to argue against anybody. I'm not saying that. The other interesting point is oil has been separately taken out.
All right, we'll see.
Yes, yes, keep it.
Now, just one
Lot
housekeeping.
of the
some
field will be
housekeeping issues. We will give 1 day now for the remaining council on this side to argue the matter. And
Lord, I would take one session, that's all.
right. What we
I
will
will take one session.
what we will do is this.
Yes.
The same mantra as we normally follow in all other
My lord,
cases.
I can assure
The
your lordship,
remaining council, please, including the solicitor, ration the time.
yes,
we'll give you
will
the
not
whole-
repeat or,
We'll give you the whole of Tuesday to conclude the arguments on this side. We'll then give Mr. Dwivedi one council in rejoinder, please, on Wednesday, and that's it. Mr. Dwivedi, we will hear you in rejoinder. We'll give you a day in rejoinder, and then we'll.
I'm grateful.
Lord, one more thing, Lord, as far as some cement
One day
companies,
sufficient.
they've also been tagged along. There are two cement companies, Dalmia Cements and Ramco Cements.
Tell us-
With subsoil rights, that also, that can be go later.
Correct.
And Lord, on this question of entry, I just want to make submission.
On
that-
Thursday evening, with a miscellaneous day to follow, I don't think our receptivity about
No, no,
dealing
no,
in
no,
matters
no,
is
no,
very
not
high.
the- It's just one last thing, Lord. I'm just making a submission on harmoniously reading 49 and 50.
no, that is to be argued on.
I'm going to argue, I'm going to take analogy of sales tax. Lordship, please give me 10 minutes on that. How parliament and state powers are balanced.
We'll hear whoever has to argue.
Because Lord, what happened?
Subject to one underlying ground rule, which is that we are all going to conclude everybody on this side by Tuesday. Wednesday, 1 day for the
Lord,
rejoinder.
that your lordship
Only
may
one thing,
to
only one
keep it a little elastic
Thursday,
without
Lordship
repeating.
is keeping Thursday in reserve. Give us half day extra on
Thursday,
Wednesday.
all the benches
Let
have
this
to go
side
back to their regular work.
on Wednesday.
We have enough work, regular work to do on Thursday for all the benches. Wednesday evening at 4 o'clock, we'll conclude.
Not the difficulty, Lord, difficulty is this.
Some more time.
Lord, we are not arguing anything repetitively.
No repetition.
There will be no repetition.
But we have divided
It's a 9-judge combination. Lord, if anything is decided,
all
we'll
constitution
have
benches-
ramifications.
In all constitution benches, we are strictly stuck to time.
But
We'll
there's
do
one
that
thing
in
I
this
will
case.
say. I've, with a few years at your lordship's bar now, seen one thing. If you hold the judge's interest, time is never a constraint.
Yeah, well, my learned friend is right. Even
Only.
I have appeared before your lordships don't stop.
Only liberty we are seeking is
Subject
just
to,
in case.
subject, there is no just in case. If there are Supreme Courts in the world which give half an hour for a written, for an oral submission, surely 1 day for people who are arguing after 3 days of arguments on one.
My lord, new point. Let's not, my lord,
There'll be all
waste your
fresh
lordship's
points.
time on that, my lord.
All fresh points to assess the court, my lord. All fresh points.
1 day, Tuesday evening, we are closing. Please meet in advance and divide and ration.
We
the
have
time.
done that. We have done.
So 1 day for this side. Wednesday, Mr. Dwivedi, we are going to have only one argument in rejoinder. Otherwise,
We're
it
only
becomes
pleading for
impossible.
a small delay.
Interveners and everybody coming in.
We're only pleading for a small.
Lordship has Thursday in hand, Varus. Kindly give us
Just
that
one.
Thursday. I know Lordship is keeping a Thursday in hand, Varus.
Lordship,